things that shouldn't have been there. Yes?
Thank you. Assuming we have framed issues and maybe by oversight of either court and the parties, an issue on a time and we read pleadings and I'm writing a ruling and I find there is a PO on time limitation. Do I keep quiet on that because parties didn't address me on it and resolve issues before me?
If you find there is a matter, it would be parties should, but don't ambush parties. It's not your case.
Saying it is false?
My Lord, we were guided yesterday that you write the judgment both for the winning side and the losing side. And my Lord, it was emphasized that in the interest of both sides.
So that is false. Next, ED.
A sound judgment may not provide reasons for the decision made. A sound judgment may not provide reasons for the decision made.
True or false? Who is saying false? Huh? Yes, but why?
In my view, I think that every decision must have a justification. So the judgment must have reasons.
I think that is true. You must give reasons for every decision that you make. Yes?
What matters in a judgment are the facts. What matters in a judgment are the facts of the case.
Is that true or false? Who is saying false? Yes.
We look at both the facts.
Very dated. What else must have must be dated. What else must have must be.
Transparency reason
is the work of
transparency reason
is the work of higher courts.
Wish to play
Higher courts.
wish to play games very well, mate. Games very well, mate.
But it will serious people will not proceed to file appeals against such a judgment. But otherwise, the intending ones actually are doing it every day. They're applying for injunctions when they shouldn't be having, and then abandoning the cases. So, yes, you are correct. People who might have filed appeals will not.
judgment must have a
Attributes, is it true or false? We don't want to pick it. Is it true it must have the essential attributes? Is that true or false?
Maybe we need to first identify those essential.
Yeah, and that
attributes
is
of
why
judgment.
nobody wants to say, because the
Yes.
next question, because yesterday let's do it one by one. Go flow of reasoning. The microphone is there.
Logical flow of reasoning.
Reasoning.
Faithful
Yes, Your Worship. What we should begin with, okay? Issues we want, so the as it is that judge true or false? Disputes and does not serve any serve. Accountability, whose account does it serve? Judgment serve. A good judgment, what does it serve? It checks backlog, I think, because the appeals are few. What else is there?
This is true or false?
Yes, yes, they do. How do they play? They do. How do they play a role? A role. Mike, who is? Give it to this lady here. How does it play a role in economic development, a good judgment?
Consistency enhances investor confidence, where they're sure of the decisions that come out of
Investors come knowing that this is what we are moving into. In this country, this is how this matter will be solved. Isn't it? This is how this matter will be solved. Isn't it? So it attracts investors.
And judgments that are acceptable to the public also promote security, though indirectly.
Judge feels safe. Anything else? Yes, sir. Give it to the lady there you are passing.
When adequate compensation is awarded to investors, it promotes more investment in the country.
Why only investors? Let's come back to the farmer down here in Bwizbwera. What does he benefit? The farmer there.
My Lord, we've just seen that a good judgment reduces case backlog. And once there is no case backlog at the courts, it means that all other cases are going to be handled faster and easier, and then the people from the grassroots, the people from Kagango in Shema, will get justice faster.
Thank you so much. Doesn't it cut the cost of administration of justice? The lesser litigation we have also benefits the government in that it uses less what? But it also enables removal and decongestion of prisons, because you can then have time for dealing with the civil matters. I want to thank you very much. Yes, my Lord.
I wanted to share on whether it is acceptable for a judgment to have some issues not raised. I agree entirely with the views which have been expressed. But let me share this with you, my experience. One day, in an attempt to really leave no stone unturned, I really used to be thorough. Leave no stone unturned. Then one day, a judge of the appellate court, Justice Beko, called me and said, Justice Bamwine, your judgments are wonderful. They are good. Keep it up. Said, thank you very much. Then he said, but you indulge in matters which have not been raised. During trial, not covered under the issues for determination. So you should avoid some of those issues. You don't have to talk about them because they were not raised. If you have an opportunity to raise them later, you will have opportunity to talk about them in another judgment. I was humbled. And those are the sort of people we need in society these days. You don't have to write 70 pages, 50 pages, where you could have written 15 or 5. Simply you want to ensure that there is no stone. You are not leaving any stone unturned. Stick to the issues for determination.
Thank you very much, my Lord. We of course have we know amongst us who writes 50 pages. covers everything actually that should have been covered. 50 pages, 58, 72. You go back to history, when the law of theft began, because you want to explain that there was theft of a cob of maize. But you go back to history, you go to Europe, you come around, you cite every step a case, 1782, 1820. Because you want to say this fellow stole a cob of maize. No, that is for classroom, for the professors and so on, to tell you, give you history, a background. So yes, I agree fully with his lordship. I write very short judgments myself. I'm actually happy when I write 70 pages. I'm very happy with myself. When I begin going into 15, I begin sensing there must be something wrong somewhere. Otherwise, what am I writing? So we are going to look at, we've been dealing with judgments, we've been dealing with court record, we've been dealing with procedures. We now want to look. Where is Dr. Nakibole? You are the one, isn't it? Are you coming here? Yeah, we now want to look at shortfalls. Shortfalls. Our records kept properly. When I get your file and open, do I understand it immediately? There are files which are upside down. When you are writing your judgments, is that file complete? Or do we have other things that shouldn't be there in that file? When we are making decisions, don't they threaten the very meaning of justice itself, that law one? Don't they threaten that the very meaning of justice? So she will take us through, in about 40 minutes, she'll take us through those shortfalls and so on. I think yesterday you were given a bunch of documents. What, did you get them yesterday? Yeah, those are the ones she'll be referring to. She'll be referring to. Your worship, please.
Good morning to you. I'm just going to do a lot of trotting around. I think it's good for the exercise because some of my things are hyperlinked. Now, my presentation speaks some, few. Okay, this will be the structure. We'll fast track digested simulations, which now we want to track the birth of a judgment or a decision right from a case birth, once registered, up to the time of case retirement. So we'll give you scenarios in the pre-trial stage, both civil, criminal, trial stage. You have them post-trial. We have some examples. And then there are specific ponders that, or pitfalls that normally we just gloss over. But then most of us are victims to them. Of course, the objective, just I'm emphasizing, is to equip you with the hands-on practical exercises regarding the step-by-step processes that feed into the judgment or the final decision, which we may disregard, and then somehow they impact the judgment writing. My point is that you must start your judgment writing in your mind right from the time you get the file. Study the file, think of what is coming through, what could be the probable. So you work with your judgment right from the time you get your file. Of course, there are also alerts on troubleshooting spots in judgment writing. Incidentally, like Justice Bamwine spoke to it yesterday, any decision we make, even if it's a ruling, it has to follow the steps of judgment writing, however brevity it is. So we want you to all acquire skills in the decision preparations, right from even the case management of a record. Because if an exhibit is not properly attached, you may miss it. These will all impact on your final write-up. Okay. As I said, you are going to go through stages: pre-trial, trial, post-trial. Let me try to see how fast I can be. Plea-taking. Sorry to keep on emphasizing plea-taking, but it's a very common pitfall for all of us, especially when you have sessions for plea bargaining or sessions like you want to finish 40 cases. So somehow we forget the facts or the way we have to do it, and this always impacts on our decision. You have these case scenarios, Zakayo, and let me just okay. Tony.
Tony.
Okay, there we are. It has come. Of course, you all had it. These facts of Zakayo, if you look at them, let me sit down. What do we note here? The basic problem we have here is we forget presumption of innocence, even during plea taking. Some cases are very annoying, and you simply forget the presumption that this accused person before us is innocent. Now, this is a precursor of Adan versus Republic. Zakayo was charged with theft of cattle. He's brought before you as a magistrate court. He admits stealing a bull he found in a family kraal with other cattle. If your mind is now not preset into a presumption of innocence, you will say that now since he has admitted, let me enter plea of guilt, and that he was arrested with it. So, as a trial court, you enter this admission of as a plea of guilt. The prosecution does not make any statement of facts to the court, but you already made up your mind that this man is guilty, he stole an animal. Now, without taking any interest in knowing the circumstances under which this accused person could have committed an offense, whatever the offense is, you record a conviction. You see the pitfall. Now, the prosecution in this matter scenario informs court this person is a first offender. However, stock theft is a serious offense. Treason is a very bad offense, given the political arena. So they have a way they talk to you, and then you waive the presumption. And he seeks a deterrent sentence. As a trial court, you sentence Zakayo to 7 years imprisonment with hard labor because of theft of whatever, and then 10 strokes of the cane. I gave you tasks there. Is the plea legitimate? Is it an unequivocal plea of guilt? Is it voidable? What are the accused rights of presumption of innocence vis-a-vis his plea? What would Zakayo's plea record ought to present like? I'm just emphasizing that step-by-step Adan versus Republic decision. So what are our points to take home? Plea taking highlights. If I were you, if I go back in my education process, I think I would just have the points in Adan laid down and placed on my clipboard so that I follow them as a Bible. So the highlights are very important. Otherwise, they defect or impact negatively on our decision making and cause backlog and unnecessary appeals. Then let's go to a second scenario. You have it. This was Mukasa. Now, in this case, this accused person had caused grievous harm, appeared before, actually he was mad, appeared before the first trial magistrate. Good enough, the magistrate noted the conduct, the scenario situation of this accused person. He ordered for an order that he be taken to Butabika for examination. Okay. Unfortunately, like you can't have a choice, he was transferred before the report to the court on this directive. Now the file was brought to the attention of the second trial magistrate. This is a very common pitfall during our management of case files. You don't read the file properly, files allocated to you, you don't study properly what happened to the other one. what happened before your time. Now he just goes on to read the charges to Mukasa. Mukasa pleaded not guilty. Then the court ruled that he was fit for trial because maybe the handwriting, and he did not read a past record, despite the submissions that maybe we had an order and this man could be mentally unstable. We have the pressure of having cases completed so much. So he convicted Mukasa and sentenced him 7 years imprisonment. So you see, I want you to think through, what are the procedural irregularities in the above scenario? I've hit on some, like case management, reading the file, mentally disturbed, how do you handle them? And what would you do differently to help you write better? What would you do differently to help you come to a better decision about Mukasa? So that's why we come to this pitfall, challenges of mentally challenged persons during plea taking. It's very important. Then another thing, we get bail applications. They are a dilemma. Okay, but I wonder if they intervene, if I could hit my 40 minutes, or they intervene after. Allow? Okay, okay. Much obliged. Much obliged. Bail applications. We go back? Yes, Your Lordship.
Yes, thank you, Doctor. I just wanted to share, in cases, especially people with mental challenges, sometimes you may find that the judicial officers have changed. The files sometimes don't have the documents. The state attorneys have also changed. I think it is wise to also inquire from prisons, because I had a similar case where the judge had ordered for a person to be examined, and that record initially, I couldn't say it actually on record, and we were proceeding. And I'd also asked prisons, especially starting with a pre-session meeting. And they said, but this person didn't seem to be fine. Now, the only people who had a report that the examination actually had been done was prisons. And the state did not have anything to do. So I'm just highlighting it in addition to what you had said, that I think it is important to inquire from all the stakeholders. It may also come from prisons in this case, who are the custodians or the person.
That's very true. Thank you for the feedback. Any other reactions so far? Should I proceed? Yes, research indicates that they are common. Research indicates that they are underprivileged under the trial system. We sort of like fail to take note. Okay. Research indicates that these are common scenarios. Research indicates that these people are more vulnerable. We sort of like underlook that challenge they have and just proceed. And research also indicates that some judicial officers don't inquire into scenarios of when accused persons or people before them present in an unusual manner. For example, a man comes with dreadlocks, he has a way he changes like this, coughs, and then maybe he doesn't want to speak. Or you must, as a court, be alert that perhaps there's something wrong. That inquisitorial during the plea-taking stage has become a very big challenge. Yes, Your Worship.
What we usually see is actually people that are mentally challenged, and it seems like the community wants to seek some relief from them, so they bring them through the system. But there are also these ones that are in the habit of drug use, substance abuse. So you find that at the time when they bring them for plea, they do not follow. And then, because you don't have a formal report, still by your own assessment, you think that this person doesn't follow. You try to ask them, clearly you see that they don't understand what they are responding to. Usually, sometimes, even though I know it is not the right thing to do, we still remand them. But when they come back, you find that they are now clear in the mind, and then they are able to answer. Now, your own assessment, you find that they are better. So I think those cases are really there, but a lot of them are out of substance abuse.
So the common pitfall is that even if this person really looks like he has been his subject to substance. Do you remand him? Have you inquired? Maybe it is he's going under whatever rehabilitation. Now, why do you read the plea when you know he will not understand it? Or when you try to read it, does he understand it? Now, what is your role as the trial court? Then you remand that person. Those are the kind of scenarios. So in our court, this CC meeting or RCC meetings, you have to address such scenarios that when you bring this accused person before me, I mean these mentally disturbed people, at least also you take the charge to get maybe their examination other than dumping them to us in court. So it's a common role, it's a holistic approach for all the justice actors in this system, other than leaving it to you, carrying it on your own, and then further remand this person. Yes. That's my thought.
When you look at this, the behavior, because when she's doing troubleshooting, the issue of the behavior of the judicial officer is important. The judicial officer in this case is told by the prosecutor and the defense that Mukasa has a problem. The court turns himself into a mental mental illness trained doctor and says, no, he is not.
He's okay.
But these people knew the history of Mukasa. So think about the behavior of the judicial officer, because once you are in the chair, you then think that the whole world must. That is where the problem.
Okay, any other question? No, I proceed. Okay. Bail applications. Colleagues, this is a very, very, very challenging area. For completely, in most cases, forgotten the right to apply for bail. Okay? Someone comes, you mention, tries to apply for bail, say next time or further remanded, and then they have the right to apply for bail. However bad the case may be, you have your discretion, because the application is handled by the discretion of the judicial officer. Now, let's go to the scenario. Now, this is a very annoying scenario. This Sendagire man, but this is a true case. Sendagire was charged under the Computer Misuse Act for posting on his Twitter and TikTok handles that the president of Batuma land is not of Batuma origin, has a hexagonal shaped head. He has popping eyes and is aged. Actually, is about to die. Now he's brought under the Computer Misuse Act and he applies for bail. There's a common mischief that we tend to get angry at some of the facts. And for me, I always tell people that for me, I'm indifferent. Nothing can touch me in a trial. And over years, of course I've been around. I've really been around. So over years, I've grown that immunity. Nothing touches me. So, and I think that's the best way. So ponder on this Sendagire's constitutional bail rights with a holistic lens. Despite all he has said, and despite all interests, conflicting interests, in line with the International Bill of Rights, but morally, Article 28 and 44, the right to be heard, which is non-derogable. Very bad scenario. And enabling laws, of course. What does the MCA say? What does the TIA say? And what does the Computer Misuse Act say? But of course, there's also we also have, what does case law say? I wanted us to think about that legal class case. You know it? This was a matter that was brought on a constitutional reference from Justice Ogola. Justice Ogola sent it to the Court of Appeal as a constitutional court to interpret, is there the right to bail? So in this class case decision, that's when Justice Chikonyogo, the late, heading the bail, came out with the class case distinction that there is no right to bail. But there is a right to apply for bail. Sometimes counsel, it's a common mischief. Sometimes counsel says, I have a right to bail. She has a right to bail. Has a right to bail. Has a right to bail. As a judicial officer, remember this application is within your discretion. You just say, okay, right, bail is not automatic to become a right because it's discretionary measured by the judicial officer under the circumstances. But the party has a right to apply for bail. Now that's where we all fail. You further remand, it's a sensitive case. The man has a right to apply for bail. Vide Article 28, this right for a fair hearing, he has a right to be heard, and it's non-derogable. You have no choice. Big case, bad case. You must hear it. Yes, Your Lordship.
I want to add, that's a very sensitive subject. And if you fail to get bail today, you can apply for bail tomorrow without prejudice.
And then a common mischief. This person has indicated, I want to apply for bail. Okay, for your reasons, whatever, you remand. Not having had him. But then you remand for 14 days. Why do you extend it so far? Then you remand for another month. But you've not had this person's non-derogable right for a fair hearing to be heard on the right to application for bail. Hear it, decide on it, period. Let it be off. That's another common mischief. However, you also have to be aware of the bail guidelines. So that balance is quite tricky. Any question? Yes. Yes, my lord.
Sorry, I'm very active on bail. But in the guidelines, you must give a written decision. So that may make it impossible to dispose of an application summary.
Or a specific date for all of them. I think what we should know is you are in control of your court. Take control of your court. Lawyers will want their clients to be released even before you hear them. So the pressure is much. But the judicial officer, be cautious that the decisions you make are important for all the parties before you. Your decision is important for the accused person because every accused person wants to be free. They are also important for the prosecution because the prosecution has also given its reasons. Now, take your time. Look at what has been presented before you. Study precedents and ruling. You are the one to define what time you need for your ruling. Define parties when they should come back, and you give your ruling. If it's a simple matter, do it immediately. If it's a bit complicated, take your time.
The answer has been given, and I think it is okay. So the bail rulings won't take long. But I think you must be cautious to avoid those on the spur decisions. So the good thing we have in our system is that you have an applicant and you have a respondent. Now, because you're required to give a written ruling, you ask them to put their submissions in writing. And then you make a ruling. It takes 2 days or 3 days, but not on the spot. Yes, thank you.
Thank you very much, my Lord. Don't react. Be cautious. Be sure that you are subject to criticism, and your safeguard is your ability to write a well-reasoned decision for every decision you take. It should be reasoned. It should be your best. Don't react to situations.
A related mishap is that during the bail application, the state normally, of course, it has justification. It wants its case. Normally, they have this tendency of saying, you know, the applicant, the accused person has a likelihood of interfering with witnesses, and the case is almost getting to the end, and is scaring witnesses. And then we forget the law, that where there's that allegation shouldn't come from, it should come on an affidavit. You know that step. So we've all forgotten that when somebody is trying to say interfering with the witnesses, is scaring the witnesses, the law says there should be an affidavit of that person or the confirming to that court the fact of scare, the fact of interruption, the fact. So, but as a researcher in Newly, I've not been seeing those things. So let's reflect on what the law says in all situations. Noted? Then the second related scenario is another case of treason. Now, Disalule.
On your point, my advice to you and to everyone else involved, hurry slowly. You want to get rid of a backlog? You want to, don't rush. Speed kills. Hurry slowly.
Total space. Now the fourth scenario again, now it's about this. I'll show you the pitfall. Ali was charged with the offense of treason. He applies for bail within 3 weeks. Of course, High Court grants it. But now the mentioning magistrate, somewhere after his committal, cancels the bail on the 59th appearance of his court appearance. The court accordingly informs Alule of his bail cancellation as under law. This area of bail cancellation has also become quite problematic. Why? Because of the new bail rules, matters in capital matters now, I think the applications are being handled by the High Court. So the issue is, what would the committing magistrate do? Because the old law is still on our books that bail automatically lapse. So on committal, should we take the file back to the High Court, which granted the bail, to handle it? There is some jurisprudence that's coming up, but it's a common dilemma. That's why I raised it. So there could be different views. Highlight the procedure for the above processes. That's what I've been highlighting on. And in line with alleged human rights, if any, whether they are violated or not. The man was released on bail. It has lapsed under law. Trial magistrate, you are cancelling. Bail was handled by the High Court. We have the bail guidelines. How do we handle this scenario? If you could share. Magistrates, how have you handled it?
Doctor, my name is Mbarara Esther. Bail was granted by the High Court. There is a constitutional court decision that offers guidance on that. Bail does not lapse upon committal. The ideal would be if a state attorney raises a concern on bail cancellation, I commit this person to the High Court and I make a mean ruling on that, basing on that constitutional court decision. if the state attorney has any other issues pertaining to the bail of this person, he or she can raise those issues before a judge in the High Court. But a magistrate has no jurisdiction to cancel that bail. Thank you.
As a magistrate, I can also have the other view. Especially if you are somewhere who belongs to where I come from, academic, and you say there's statutory law in books. So the debate will be case law versus statutory law. So don't you think there's high time? It's wrong because we have a law in book, and the law in according to thesis or hierarchy, the case law is above the case law. The statutory law is above the case because it's a statute, it's an act. So don't you think we need Honorable Emeritus DCJ, Honorable Emeritus Principal Judge, we need somehow to tweak something in the bail guidelines?
I think constitution is supreme to all. Where a statute has been interpreted by the Constitutional Court, and the Constitutional Court has had a ruling saying this statute conflicts with the law, then that statute ceases to have effect. Even if it's not yet amended by the Constitution, but the Constitutional Court has actually outruled it, you don't continue to interpret it as if it has not been interpreted. So I would agree with the magistrate on that point, that you follow the Constitutional Court interpretation of the law, rather than continue to read what has been invalidated by the Constitutional Court.
My lord, a small court down there may not have that constitutional court, and because of
The
power
ignorance of the law is not going to help us. It's not useful.
So that's another dilemma. So what do you have to take home? Be alive to the right, to the presumption of innocence, among other non-derogable rights during bail hearing. We shouldn't close our eyes to it. Even if the whole battalion has landed without prejudice, even if the whole faith, say Christians, have landed and you feel so scared, remember he has this right, and some of them are non-derogable. And the bail application challenges, we must think through how do we balance accused rights, the right to apply for bail, the non-derogable right, the right for a hearing, accused obligations. Normally it doesn't come out very well in the rulings. Remember, any decision must be reasoned and must have a legal anchor. We tend just to take it just like that. You write a ruling, you don't even give reasons why you are doing it, and not even base it to the law like she has. So those are common pitfalls. Then bail application management, I've talked about it, timelines. Why should you adjourn the matter for bail for another month or two because of your case backlog? Or because you feel like it's not ready to be given bail, given the, is it your business? Okay.
One of the challenges is changing the attitude of prosecution. So you've mentioned something very pertinent, trying to oppose applications orally. Okay? They come up with all these statements from the bar. But if you insist on having pleadings and submissions, you can actually end up with a very orderly process. Sometimes they even step on what would be their strongest objections to bail by outbursts at the bar. Okay? So somebody may say, this person is a flight risk. I think for the judicial officer, then you go and look in the law. Does that statement in the affidavit implicate a particular provision of the written law? And then this thing about the court has decided, I thought that what needs to be appreciated from a drafting point of view is that these laws of Uganda undergo regular revision. And the last revision we have on the books is December 31st, 2023. Now that revision was supposed to take into account all the statements and rulings of the courts, which struck out some provisions to be constitutional, other provisions to be spent provisions, and so on. Because for the judicial officer, it may be a little bit excessive for them to be able, in that heat of the moment, to pull that case immediately, okay? To pull that case in. Because these revisions, the draftsman is supposed to take into account all those court decisions when they're revising the what? When they're revising their laws.
So timelines, bail application, I think is a quick thing. It's just a pre-trial process, part of the trial. Why do you the timelines, managing them? It's a very big challenge for all of us. We tend to dance to the gallery. We tend to play to it. And of course, obviously, in that trying to play to the gallery, bias can be detected and people can easily read which side you are falling on. So that now speaks to appearances. You can find like 10 lawyers appearing in the BCG application for bail. How do you manage it? As a judicial officer, you should have a stand. Like, if so-and-so has spoken about that point, are you raising any other point besides what he has said? Are you raising any other? Because they can all go into a rhetoric, just playing to the gallery. So appearances. And how do you manage them? You can't say, get out of court, don't get angry with them, but try to manage your timelines with appearances. Then temperament. Research shows that judicial officers, I don't know what has happened, during our days we were maybe, I don't know, maybe we were young. Why do you get annoyed? Why do you become sentimental? You are an educator and you're supposed to balance both interests, the state, victim and community, that choose persons. But we have this tendency of, we can even see in that decision of the way the judicial officer has written, the anger, like was really shaking, the venom, the might. Really? So also that one speaks to soberness. Need to be sober as a judge. Why does your face show signs? How? Can you please cancel? I mean, why is training? You will even get aged, by the way, if you are a lady. And at some point, you can even get high blood pressure. Some of us are hypertensive. Then it shoots. Then you start whatever sweating. What's the big deal? Soberness. Soberness. You are mighty, but please be sober. They all know you are mighty. Yes, my Lord.
Maybe the judicial officers, there are those who have been saying they get orders from above. So maybe we should hear whether they are those ones who get orders from above, and then that's what causes your shaking and your change of face. Then we could be guided there. As for me, I've never got that order.
Sometimes there could even be calls. For goodness sake, why should you receive a call when you're in court? Why didn't you leave your phone behind? You are going to court and know. Why should somebody call you about a matter that you are going to handle? The test of soberness is very, very challenging vis-a-vis principles, vis-a-vis political, whatever, vis-a-vis the situation, the right to be promoted. You feel like it's going to, so many things come in your head, but soberness. Normally when you are brides, they tell you to be sober because you have to push that gown, and it has a very long tail. Sometimes when you're in the dressing room, they can even give you a wine. So you must keep on smiling and kick, while you but you are kicking the gown, and that soberness is very important for us. Sometimes the English people say, get a handkerchief or a ball. You press it slowly under your table. It works. If you are so much on tension, you press it. You are so much angry, you press it, but learn not to mask emotions. Just press it, press it, press it. Then suddenly you feel relieved. I mean, it's just a file. So, my emphasis here that a ruling, a decision, at this pre-trial
I
stage.
just wanted to comment on orders from above.
Yes, my lord.
We are all here. Who has received those orders? Just tell us. Yes, give us the experience.
My Lord and Your Worship, Belmo Sogwang Opio is my name, grade 1 Isinjuro. I can share personal experience. I was handling a land matter, for obvious reasons I will not disclose. I got a call from an MP, I'm not going to disclose the name, telling me, you know, Your Worship, there is this land grabber who has brought a matter in court. And we know him very well. He has grabbed land here and there, so you need to be careful with him. You need to find a way of assisting this other party. And I told him,
the interfaces are normally legal access. We believe that the law and case law and whatever form the law might be in is a public good and it should be shared freely. Yuli has a user base of about 2.3 million users per year. Now, each month that's about 194,000 users. And at a particular second, those are about 300 users. Because now yesterday night, when I woke up to check the system, you could find that you have about 400 users at any particular second who are doing research on Yuli. Now, Yuli is an international product. It's not just for us in Uganda. Yuli covers about 45 countries across the world. I don't know if any of us have heard about the city of Kathmandu. That's in Nepal. That's as far as we go in terms of our reach. That means a decision that is passed in Uganda is read in Asia, Europe, France, whatever country you may say. So that speaks to its relevance. But for today, I am going to go through the system so that people understand the features on Yuli. Then if you require another training, you can organize trainings according to circuits around. Then I'll be able to also take you through the system again. Now, when you look at, this is the website that we all have, but you ignore this part, my Yuli account. I'll explain it in detail, because many of you don't have it because you've not yet logged onto the system. Now, Yuli has about 5 products. We have the court cases, which are our primary resource. We also have legislations. We have the gazettes, parliamentary Hansards, and of late, we are uploading case digests from the different state agencies, but also as Yuli, all cases on Yuli are now digested for ease of reference. So we also have the regional and international courts where Uganda is party to. That is the African Court of Human and People's Rights, and many others like the EAC. We also report for them. Now, I will start with the home page. Now, the home page will give you exactly what we are and what we do. Like here, you can see judgments, legislations, collections, gazettes, and many others. But also, even without going into detail, you can see from this that we have the most recent decisions. And if I may, just a moment. Now, this is a decision that was passed yesterday by the Supreme Court when they were. Now, what I am going to do is do that and save the decision. This was a decision that was passed in honor of the late Professor Justice Kanyehamba. Now, yes, I have saved that decision. Now, if I come to the Yuli homepage and I just refresh, you'll find that now it is the first decision on Yuli. That means once we get a decision, we report in real time. But you can go and here, you'll get the most recent decisions, you get the most recent legislation, and also gazettes. And as you can see, we have the most recent as 25th April, 2025. We have so far updated about 350 legislations from the principal laws of Uganda. Because after the revision, we also had to revise our system. So most legislations are updated on Yuli, and you don't have to go very far to look for the same. We also have the specific courts across the country. That means each high court circuit or division, cases are reported within that circuit or division and assigned to the specific judge who actually handled the matter. But talking about the system, I'll start with the product of judgments. Now, as you've seen from the homepage, you can search for judgments from the most recent decisions of judgments. But then also, you can use this system here. That is either the general search or the advanced search system. The general search is when you're not aware about the specific details, like let me say the case name, the citation. So you go to the general search. Now if I say like a breach of contract, and I say search, just a moment, yes. Now the ULI icon here will always help you come back to the home page, like I've just done, breach of contract. You will find that if I say search, it will give me anything to do with breach of contract. But I can also put, if I want anything to do with breach of contract and there are no other interferences within the word of breach of contract, I'll have put the quotation of breach of contract into question marks. That means it will give me exactly breach of contract without interference. That means there will be no word between breach of contract. Just narrowing the results. Now you find that here, it will give you 3,039 results if you're generally searching for breach of contract. If you put it in quotation marks, it will narrow down your search results to 1,863. Now, this will also assist you in narrowing down your research. Now, apart from narrowing down the research, you also have to be aware of the filters that are offered on the sides of the web, of the web page. In terms of judgments, if you want to specifically say, I want breach of contract within the judgment. Now, if you want acts of parliament and only acts of parliament, judgments are 14. Acts of parliament judgments are 1,038. And now you can see there are only 14 here. But you can also say, I want anything to do with breach of contract. That was reported in 2023. And you'll see that there are 4 legislations. So this all helps you narrow your what? Your search. Now that is as far as the general search system is. But then I'll go to the advanced search. Now normally when you're using the advanced search system, you have to know specifically, say in terms of the title, or in terms of the parties, the title, the names of the parties, or the case number. Now that's where the advanced system, I just type the name Orient. Okay. As you can see, any other case that has Masereka in the content. If I want to narrow down my search and I only want cases who are titled Masereka, only cases that are titled Masereka, and use the case of Zabwe. If I want the case of Zabwe and Orient, it would mean that it will, just a moment, I'll be able to, it will give me all the cases with Zabwe versus Orient. Now, these are Boolean operators. If you see Zabwe and Orient, that means it will give you cases that have the title Zabwe and Orient. But if you do not want, even O, now if you use the O here, it will tell you that I want cases with Zabwe and O Orient Bank. That is either O. It can give you one with Zabwe or Orient Bank. But because we know Orient is bank, the word or the case of Zabwe and Orient ends with bank. But I don't want any case with the word bank, but has Zabwe and Orient. I'll go here and I say not, and I say bank, which would mean that it won't, all of the search results will disappear. Because I've assigned, the instruction is that I don't want any title with the word bank. Now this assists you in narrowing down your research on ULI. But also, before we go to decision judgments, right now, I will tell you that the judiciary has been so gracious to fund case collection exercises. And currently, as we speak, I can confidently say that we have about 99% of the cases of the Supreme Court We have done so about 26,000 cases. We are going to 27,000 cases. Now, this shows you that the cases are there, as the Supreme Court has decided, to 1926. That's how much data we have on Yuli. And we've discovered 1902. Why am I emphasizing this? Because most people want to go to other sites like India, Nigeria, but I'm also informing you that our website currently has cases on all topics that you may want to find, both from the Supreme Court up to the lowest court. Now, if you're searching for judgments, like I am here, and I want to get to know judgments in Mbarara High Court, as we are in Mbarara, I'll go here and say judgments. Now here you'll be able to get the different circuits, divisions, but also we also report for judgments of all tribunals across the country. Then I'll say, since it's a circuit, you'll find it at High Court of Uganda. Now here you'll say, now this is Mbarara High Court. Now you'll find that the last case was passed in on 18th July, but also if I'm in Mbarara High Court, just a moment. Now here you'll be able to see which court I am looking at specifically. And Mbarara High Court is here. If I click on Mbarara High Court, I'll be able to get all the cases of Mbarara what? High Court. Now here, like the senior resident judge is Justice Alan Nshimye. I'll click here, and the judge is transferred to another circuit. The cases are assigned to that specific circuit. That means you're able to track cases across all circuits and divisions of the courts. But another thing we are going to go to, what we did in the last, because people would quote decisions and they are not aware whether a decision has been overturned or upheld. Currently on Yuli, you're able to know that a decision has been overturned or upheld. I'll give an example of the Supreme Court decisions. I'll pick a random case. Just a moment. This. Sorry about that. I'll go back to judgments of the Supreme Court. Now, as you can see, this is the account for the Supreme Court of Uganda. I'll look at the case of Uganda Motors. I don't know if everyone remembers the case of Uganda Motors that was decided when we were still in first year law school. There was a recent decision concerning the same company. Now this is a decision. Here I will load the same decision, specific highlighted section. If you find that this highlighted section shows that the Supreme Court overturns Uganda cases on Yuli, you have to be aware of this feature on related documents. You are able to track that the decision has been overturned. And if I click on the Court of Appeal decision, now I'm going to the Court of Appeal, you'll find that it tells you that the Court of Appeal upholds the High Court decision. But remember that the Supreme Court overturned the Court of Appeal decision. Now, when you're going through Yuli, you have to be aware of this icon here. whereby you are aware whether the case has been overturned. Other you may quote a case and actually it has been overturned. Now this cuts across board. Most of the cases of the Supreme Court, we have been able to trace for the cases from the Court of Appeal. And they are being interlinked, so you'll be able to know. And as you can see, we have traced them up to the High Court. Then secondly, when you're going through, we've managed to merge different products of ULI, that when you're reading, say, the law and the court case or the parliamentary Hansard, that says the court of the Constitutional Court where parliamentary Hansard was being discussed, you'll find the Hansard within the case. That means you don't have to go to another website looking for the Hansard. And even if it is a law, we have managed to incorporate the law within the cases. Going to look at different products. I'll scroll down just a moment. I'll look at the case of Fox Odoi. I know everyone remembers the famous anti-homosexuality case. Now you look at this case, if I load it here, and if you look at the same section I had referred to earlier in the Supreme Court decisions, you'll find that here you'll find that this case discusses the parliamentary Hansard. That means the parliamentary Hansard has been attached to the case and you don't have to go to another website to look for the same. If you click here on this link provided by the parliamentary Hansard, you'll be able to see the parliamentary debates on ULI. That means you can read this is majorly for a complete read of the system. If I go back, you'll find that the same place tells you that this case interprets the Anti-Homosexuality Act. And as you can see here, you'll be able to find the Anti-Homosexuality Act. But also, that's not all. You'll find that all applications arising from that constitutional petition have been attached to the same case. That means you don't have to go anywhere else. All these things have been incorporated. Secondly, another thing about interlinking documents, we have not only interlinked documents like the Hansard, but we have also hyperlinked. That means if a judge quotes a specific section of the law or quotes another case, we are interlinking the same, so that when you're reading a case and there's a section quoted, you can read the specific section. It is highlighted when you're reading, and the icon comes with a specific section, so that you don't have to go anywhere else to look for that specific section. So for that, you'll allow me to use my ULI account. Now this is an account. Anyone can open up a ULI account on ULI. This account, when you read a decision and you're interested in it, you save it in your account so that you can come back to it. But it is your personal account, it's a private account. Even me, I cannot access it. It is only you. You can even make notes on a decision and come back to the same notes later. No, but no, we cannot access it. Yes. Yes, it's stored in our system. No, I cannot access it. Yes. So this specific account allows you even edit a decision and put private notes on a decision that you can come back to the same decision and refer to those notes even after 3-4 years, for as long as the system is still in existence. Even when you, like let's say the Supreme Court and the Court of Appeal, where they are quorums, if specific researchers are looking at a specific decision and trying to analyze the same, ULI allows you to open up a group space where you can have those discussions even when you're in different places. Like even the judges with their researchers, they can actually analyze the case when they are at different places by everyone leaving their notes in that specific case. If I can get one of these cases here and I show an example, but this one is already saved on my account. I'm going to get a case that is, I will go to the recent decisions of ULI. I will look at the decision that was passed yesterday. Now, if I click here, you'll find that I've highlighted the heading of the what? Of the decision. But since it's going to be an example, I can add a relationship, which means I can relate it to another case I'm referring to, so that when I come back, I know these cases are related. I can also add a comment. Now it will bring a box here and I say good precedent. But anyone can add whatever comments they want to add, and I say save. Now after saving, you will see that it has been added to my private Yuli account, because I will want to refer to it later on. So when I go to my private Yuli account, and I I explore my account, I look at the documents that have come through, you'll find that it has been saved as the last document here. And the comments are also there. That means even after 3-4 years, I can come back and refer to the same decision and follow whatever comment I have made. But even when you're making your judgments, as long as you have a Yuli account, you can write your judgments on Yuli, because it's totally private, no one can access it. I can know the number of people who are accessing the system, but I won't know what they're doing at a specific time. So even when you're writing your decisions, you can write your decisions in your private account on Yuli, so that you just read them, because remember the authority is here, so you can just come and refer to the authorities, put them within your notes, and then when you make a final decision, you just print it out on your system. So that's the advantages of having a Yuli account, and it's totally free. What you just have to do is log in with your email address. So you'll be able to just say if you have a Gmail or a Yahoo account, you log in with that account, and then it will be able to give you that kind of access. Then I'll go back to show you another aspect on Yuli, is about, I'll use the case of Luzinda versus Sekamate. Now, this case specifically, if you look here, the highlighted section that I had put, you find that in the judgment, the judge stated that counsel for the plaintiff submitted that there was a valid contract between the plaintiff and the defendant as defined under Section 10 of the Contracts Act. If I come here, it will be able to give me the specific section referred to in the judgment, which means you don't have to go again and read the what? The law. You have it within the decision. But more importantly, and this is a plea to all judicial officers, when you're drafting your decisions, please follow the OSCOLA system of citation. I think we all know that when we're in first year, we were taught about square brackets, round brackets, but most times when we are in practice, everyone will want to say, this versus this, Supreme Court Civil Appeal, number this of 2010. The reason for this is that if you correctly cite your decisions and the laws, because I know the laws, we are supposed to cite them in the Nkoma system, Nkoma and Toso system of citation. Basically, that means linked hearts. For OSCOLA, I'll use this case as an example, the one I've already opened. If you use Luzinda versus Sekamata and 3 others, civil suit number 366 of 2017, but you find that the correct citation here is this citation. Now, this is a unique identifier. If you include these numbers on your decision, any system in the Lee family will be able to capture it and interlink it with any decision that cross-references the same. Now, basically, the square bracket means here the year when the decision was passed. This will tell you UG is jurisdiction, territorial jurisdiction as a country. Now, High Court stands for High Court of Uganda, and now this will tell you the specific division or circuit where this is coming from. Now here CD will stand for Civil Division, and number 20. That means in the Civil Division, this was the 20th decision that was passed in the year 2020. So if you correctly cite your decisions and use the full citation as has been used on Yuli, the system will be able to pick it and to make it easier for the system, because right now Yuli fully incorporates artificial intelligence, which means if you correctly cite, the AI system will pick it up and cross-reference it with any other decisions. To maybe explain that more, I'm going to use the case of Frederick Zabwe, but I'll use the advanced search system search for the same. Orient. Now, if you look at the case of Frederick Zabwe, you'll find that, as was seen in other cases, you find that all applications that are rising out of Zabwe are mentioned here. But more importantly is the section of citations. Now, if you go to the case of citations, now here you'll be able to get to know any case that has quoted Frederick Zabwe. You'll also get to know any case that has gone against the decision of Frederick Zabwe. So this helps us because the judicial officers in these matters correctly cited their cases. That means the system was able to pick up these and say, no, this case is quoted in Frederick Zabwe, and this is the case. So you can analyze and know whether a case has deviated or agreed with Frederick Zabwe when you're reading. Also, you should also get to know about this section of citations. Whether a case has agreed or not, you'll be able to find it within this specific section. Even the Constitution here is quoted because the system correctly picks up the Constitution and cross-references it among all different products on ULI. Now to also, I'll also go to legislations. Now, on legislations, you'll find that, but allow me go back to, for just the recent decisions on ULI, and you'll have a look. Now, this is a case that was quoted yesterday. Now, if I click it, because I have a ULI account, I am able to do this. I say full summary. You'll find that the case has been digested for you by artificial intelligence. But the advantage with our artificial intelligence, it is specifically for cases. We are now using it in 34 countries in Africa. So it accurately will digest the case for you. That means before you read 200 pages, you'll be able to get all the principles within the case, the facts and everything within this specific section. Now, this is the case I loaded today when I was making this presentation. That means the summary takes about 15 minutes to appear. The system can read a 200-pager within about 30 seconds. And you have I will go to legislations. When you're looking at legislations, you'll find that we have the current, recent, subsidiary, uncommenced, repealed, and all legislations. Now, why this is very important is because I think about last year, there was a constitutional petition, and they were not sure whether the law was still in existence. But the ULI system is able to tell you that this law is not in existence. You go to repealed legislations. In this specific section, you'll get to know everything. But also, when you open the specific legislation on ULI, at the top, you will have something like this in red, telling you the legislation is repealed. You have the most current legislations. Those are the legislations that are in force. They are here, all of them. You have the most recent legislations. And as I had said, we have until April 2025. Right now, we are waiting for the gazettement of the UPDF Amendment Act and the others that were passed in the past 2 to 3 weeks so that we can put them on the system. Then we have subsidiary legislations, uncommenced legislations. These are legislations that are in existence, but as a unit, we don't have the commencement instrument. Now, as we only look at the gazetted commencement instrument, that's why you see now these ones are here because there is no commencement instrument. We have repealed, as I had said, and then all legislations. Now, I would advise that when we are searching for legislations, use the all legislations icon. It will be able to show you the repealed legislation, but now here you're accessing all the laws on ULI, and I'll specifically start with the Constitution, since it's our supreme law. Yes. Sorry. Now this is the Constitution. As you can see, for repealed legislation, up here it will be red, and you'll be able to know that this legislation has been repealed. For now, this will tell you this is the latest version of the Constitution, which will mean that all amendments, even with the revised copy, have been added to this specific legislation. Now here, the document detail will give you the Constitution as it is. But you have to know that there is a table of contents for legislation, so it can help you. So if you are aware about a specific section, you can use the table of contents here. Because now here I can decide to collapse it, and then the table of contents only gives me chapters. If I say expand all, the chapters will come with what is said in the specific sections. And if I want to say, I want to talk about chapter 1, chapter 2, I can specifically say chapter 4, and I'll go to chapter 4. Now, this is the advantage of the table of contents. If I want Article 20, I'll go to Article 20 specifically. So the table of contents allows you to easily go through the system. So I'll go back. The preface, yes. Now, but also importantly is the history of the legislation. Now, I think the first revision we had was 1964. Now, Yuli gives you the revisions from the earliest. Say 1964 up to date, 1964, 2000, 2023. So you can track a decision on Yuli and read it as per 1964, as per 2000, and as per 2023. So we provide that history here, and as you can see, there was an amendment in 2018 of the Constitution. So you can easily read the amendment as it is. That means if you're handling a case before a specific revision or amendment. So this is it. This is the amendment. That means you're able to track. Now, you'll see this yellow mark here. It will tell you when it's supposed to commence. This is 5th January 2018. Thank you. So, if I go back to this, we have seen the history of the specific legislation, but we have also seen related documents. Now, the related documents are all amendments that have been applied to the Constitution, and you access them as they are in the history. But you also, this section, as we had looked at in the court cases, you'll get all the court cases that cite the Constitution and the specific provision of the Constitution. That means if it is, say, Article 20, you'll be able to get a specific decision citing Article 20. That means you can do a comparative analysis with the facts you're handling. It will also tell you cited documents. Now, the Constitution cites these amendments and the specific laws. Then it will tell you the Constitution cites specific gazettes. The Constitution cites the acts of Parliament and gives you all of them. Then even the parliamentary Hansards. If you find that here we have said that the Constitution, as I told you, we have incorporated the parliamentary Hansards, but this one will tell you that this parliamentary Hansard cites the Constitution. We also have the judicial, we are trying to add the bench books we have on Yuli. And as you can see here, the Constitution cites the bench book because in the bench book the Constitution was used. And on Yuli now you're able to access this gender bench book. We are in the process of adding about 5. Now it will also tell you about subsidiary legislation. But also, as is in the cases, you'll find here at the heading, it will tell you when it commences, and it will give you all the amendments. But it will also give you the hyperlinks as provided for. As you can see, just a moment. I'll use another legislation to explain what I want to explain. I'll use the Penal Code Act. Now, if you go to the Penal Code Act as it is now, you'll be able to realize that, as was in the Constitution, it will give you all the history of the Penal Code, how it has been amended. But also you are aware that even after the revision of the Penal Code Act, there was a corrigendum that was passed, whereby major laws within the Penal Code were changed. We also have it. It was passed, that was on 24th of December last year. That means this specific document, it is up to date. But what I wanted to specifically refer to are hyperlinks within a legislation. Now, if this specific legislation, like here, excuse, this specific section of the legislation refers to another section within the legislation, which would mean like is in the cases, you don't have to open this other section. You just come here, put the cursor here, and it will give you the specific section that is being referred to on Yuli. So basically, this is it about legislations, but you can also see it's being cited. I will go to the parliamentary Hansards. As you can see, they are also on what? On Yuli. But also we have the international courts as I have said. We have the East African Community, that's the AC Court. We have the East African Court of Justice. We have the East African Court of Appeal. Now, that is the IACA that we all knew. Now, IACA used to sit in the 3 African countries, Kenya, Uganda, and Tanzania. Now, this is a joint effort whereby if I discover cases of IACA, like we discovered about 6 months ago, we discovered 30 cases of IACA in the Supreme Court of Uganda. We were able to scan them and upload them on the system, which would mean any East African country like Tanzania, that has a Lee, will be able to have this icon on their specific. Now, we are using it to collect cases in Kenya, Tanzania, and Uganda, whereby we all put cases on the same system. We also have cases on the African Court of Human and People's Rights, African Commission on Human and People's Rights, and the AU Charter and Treaties. Now, why do we do this? Because as long as Uganda is a member of any specific regional court or anything, we are also now have a right to upload all their decisions. Yes. But more importantly, let me specify about the MyUli account, because I wanted to speak about it independently. Now, this ULI account is very important. Why do I say so? You just have to sign in with your email address. Let me try logging out and we'll go through the process step by step. I say log out. Now I've logged out of the system, of the specific system. That means anywhere I want, let me use this one. Now you find that I no longer have my ULI account here signed in, which would mean if I click on this specific decision and I say read full summary, it won't allow me to do that. It will tell me login, which means I'll come here and say login. I say I want to log in with my Google email, which normally I use because I don't want to forget the password. Now it has enabled me to sign in. That means now I'm able to access the full case digest, as you can see. But what is the future of law reporting in the country at the moment? The judiciary is going to introduce something called street law, which would mean a magistrate or a lawyer or a student who is up country, whether in Atiak, whether in I don't know if there's internet in Deja, but you'll be able to access. Now, just use it as a hypothetical example. Yes? It is a hypothetical example, but you're going to be able to access this system without the internet. That means you'll be able to access all the legislation, all the court cases, like a person in Kampala with full internet. And I believe it will be in the next 3-4 months. So that is one of the developments that's coming to ULI. But also, as you can see, ULI is a fully fledged AI system. ULI can even tell you that on this specific concept of the law, based on the decisions in the Supreme Court and the Court of Appeal, and with the given facts, that is the position of the law, and that's where your facts are supposed to lead you to. You understand? So the analytical system on ULI is very good. So you can actually use it to look at your facts and know that this is the position of the law and this is what it's supposed to be. And can accurately give you specific examples of the law, specific scenarios that given those facts, this is supposed to be the position of those given facts. I know this has some bit of interference with our independence, as people may say, but at least you're able to correctly know that if I pass a decision and it goes on appeal, this will be the specific position. So you're able to know. But on performance analytics, if you realize that when I went to Mbarara High Court and I specifically said I want cases of His Lordship Alan Nshimye, it did not give me the numbers His Lordship has done, because now that data we cannot put it out in the public. So there is a backdoor system about ULI that gives you performance analytics in terms of how is a specific circuit or division performing. Now, the idea about Yuli is not even the number of court cases we have, is what that data can do for us. Let me give you an example of gender-based violence. Yuli can correctly tell you how many cases on appeal on gender-based violence have been upheld, how many have been overturned, and for what reasons. Yuli can also inform trainings in specific areas of the law. Like yesterday we did plea bargain. Yuli is able to look at the Court of Appeal decisions as far as plea bargain is concerned and tell you this is where the mistake is most common, and this is where training should be made. So the importance is more about what the data can do for us than even in the what? In the numbers. So whoever has a decision, I would tell them, please send it to Yuli and we upload it. Now there is a question of whether or not a specific decision qualifies to be on Yuli. Right now we upload every decision on Yuli, but probably if they put an editorial board of the Judicial Training Institute, then we shall be able to know which decision to upload, which decision not to upload. But if you realize that in Kenya and Tanzania, currently they have already passed a decision that they are even uploading the magistrates' court decisions. Not because of anything, but because of the importance of the data. Because that kind of data can inform even the trainings within the magistrates' courts to tell you that, okay, at CM level, this is where a training need is, based on the data that is what is given. I don't know if we have any questions concerning the presentation. Yes.
Thank you, Your Worship. First of all, thank you for the great work you're doing. Personally, I use Yuli a lot, and it's really helped me a lot with my research. My question is about the AI analytics for decisions which were uploaded on Yuli by scanning. I noticed some of the decisions are just scanned. When we are looking at the analytics, like when we are doing searches for specific, let's say, breach of contract, and it's a scanned decision, does the AI also capture the scanned decisions or only those which were uploaded in Word and PDF directly?
Now, I think I've understood your question. Now, for AI to be very effective, there's what we call OCR readable. You get it? That even if it's a PDF, and the most common simple way of looking at if a decision is machine readable is if you try to copy and paste the what? The decision. If you try and copy and paste and it's all blue, that means you know the decision is machine readable. If you find that you can only copy and paste 2 or 3 pages, you know the decision is not what? Machine readable. But as you can see on the most recent decisions on Yuli, all of them have case digests. That means the decisions are machine readable, because we have gone from just receiving any document to trying to collaborate with all the SADs across the country and some of the researchers across the country, that they send machine readable what? Documents. We also try to take our time to explain to them what kind of documents we want. And I think Justice Kalori is my witness. When Kabale was opened up, we had a discussion on what documents to get from Kabale High Court. And I think right now it's the most compliant court as far as machine readable documents are concerned, because we either get them in RTF, which is machine readable, or a PDF that is machine readable. So we are going to suggest that even decisions that are as far as the 1970s and they are in image form, we shall remove them from the system and re-upload them so that they get the benefits of having a digest and those other things. But as I can tell you right now, we are moving to 27,000 decisions. Probably there are about 15,000 decisions that are machine, and we have about 12,000 that are not machine readable. We shall have to do, it's a whole process, and we don't want to affect your reading or your research. So we have to do it in a way that you don't even notice that I've re-uploaded what? So this is a process like we are doing the case collection exercise. Thank you very much.
My Lord DCJ Emeritus, if it pleases you, I would request that we appreciate the Honorable Justice Ngonda Antende, the brains behind this system, and the Honorable Justice Geoffrey Chiriabwire, who have really worked so hard to guide us in having this system in place. And currently, the Justice Madrama leadership that we are all following as the ICT head in the judiciary. So if it pleases you, my Lord, I would request we appreciate the team. My Lord, let's also appreciate Joel. My Lord DCJ, we are organizing the first Yuli National Conference in October. And you realize that Yuli is placing Uganda at another level in terms of law reporting. I have the benefit of interacting with many judiciaries on the continent of Africa. I think Kenya and Tanzania learned from us, and somehow Tanzania has moved a bit faster. And I think Justice Alan went together with you in Tanzania, you can attest to that. In my Lord DCJ, we are with you and Justice Alan in Tanzania. But we think that if we can put heads together, we can grow Yuli and we'll be on top of many African countries, or if I'm not mistaken, we may lead them. But for that to happen, their worships and lordships need to subscribe and get accounts. I think, as Joel indicated, we need to focus with the ICT leadership at the judiciary, led by Justice Madrama, to intensify trainings for judicial officers. Because you realize when Joel was speaking, a number of us were not able to follow. We need a bit of time, and for you to appreciate this system, one needs to navigate when you have your laptop, so that you move step by step, step by step. Otherwise, thank you very much, my Lord Justice Wangutusi. I now hand back to you.
Thank you very much, my lords and your worships. I think let's recognize one fact. Okay, we need training, but we must be willing to learn and willing to adopt to technology. Why? Just Kauka mentioned the trip to Tanzania. Tanzania has a central room for case reporting every morning. And from every corner of the country, the cases that are registered are reported automatically. The decisions of each judge and magistrate, from the border with Malawi, the border with Uganda, the border with Burundi. Tanzania is more than 4 times bigger than Uganda. But every judicial decision is reported instantaneously. Even where they have no network, magistrates use modems. But we are failing to report our activities in Kampala, in the High Court and on Uganda Road. Do we really, is the problem training? Until we change our attitudes, we are going to be trained, and we shall get nowhere. We have to change our attitudes and adopt to technology. So until you do it yourself, when he was presenting, I had my computer here, it is not difficult. For the young and for the old, there are no excuses. Let's change our attitudes. That's the only problem. Someone is mentioning using Yuri a lot from Sanga. People on Uganda Road are not doing it. Thank you very much. Just want to say.
Maybe, my lord, before Justice Wangutusi, PJ Emeritus
Yeah.
was nodding his head in the course of the presentation in agreement, if you could say something.
I was intrigued by the instant summary you get after a judge has delivered a judgment, summary of the case. It's something that used to give LDC publications hard time. And yet people do not have time for that sort of thing, to read the entire judgment. But now it can be, AI is assisting to summarize those judgments. Hey, this is wonderful. Yes. I'm encouraged, really. It's very encouraging. Yes.
We want to thank Joel very strongly. And I do agree that in many things that the African judiciaries are doing, Uganda normally comes them, propose them, and begin on them, but eventually we relax. And they bypass us. All things in Rwanda now, all things in Kenya, trainings and so on, we are the ones who gave them to them. We are actually the ones who designed the Kenya, for example, Training Institute for them. Then they come up and have a big building for training, they have a big thing, but we want to understand that we shall also soon be in that very position. The issue of must we upload everything is where we could do that when we are reading alone here. But now people in Mexico are reading. People in the UK are reading. Australia is reading. Should a judgment like the one you are going to look at just now, this is a judgment here. Yeah, should that one also go there? So that is something that we must think of. We did an editorial board which has the strength to say no, even to a judge, and say yours will not enter here. Yes, it should be. Say yours, with due respect, will not enter here. Yes, because we are graded. You know the graders.
My Lord.
Yes, please.
It would appear the system will now assist us when we are looking for a bad judgment, an example of a bad judgment. It will give it.
But we don't want the world to know. So let's think in that direction. I think we need to have we can find a Kakona, which is only accessible by us, and use it, and use that corner as a training section of the. Yes, Alan.
I think we need to get some clarity from the people here in Yuli, because when I'd also just come here, I have got my very nice research person. So every time he would get something, he'd want to scan it. I told him stop scanning my documents and putting them up. Not that I was worried about the judgments, but having been a teacher, I also ask myself, this judgment I'm going to write that is almost the same as all others, what is it adding? So I normally select the ones I think may be worth going there, and I tell him, I've sent you these ones, upload. But also them, they were under pressure, I think, from Yuli, telling them, you people, to show us that you're working, scan the judgments of your judges and send them. So that is how I'm a bit tech savvy. But now for the judges who may not be tech savvy, that is when you start having judgments that are going there. Every little thing is going up. So I think that one also has to be some clarity from Yuli on that issue, especially to the research assistants.
I think we could handle it in terms of statistics and performance, and then quality for uploading for everybody to read. We could have everything, that's what you are saying. Tanzania is having even magistrates, grade 1, everybody. But then for uploading, do you need to have the case we had yesterday and the one we're about to see? But they could be available for records of performance. And also what Justice Bamwine is saying is important. Bad cases are good for studies.
So thank you very much.
Lord,
We
if I just shed some clarity.
Yes.
Just the system, ULI system is able to do anything. Even there is a case that was passed at the civil division. It was a whistleblower's case. And they forgot in the title, there was no name of the party, but within the decision, they mistakenly mentioned the name of the whistleblower. So because we know about the whistleblower laws, what you do in such a case, if you get such a complaint, you either pseudomize the case or anonymize the what? The decision. The system is able to give specific people permission to say, pseudomize this case. That means there is no detail about either the parties or anything that will appear. And can also tell you, like when it comes to children, like the family court, like the handle, I'm able to block the public from seeing specific decisions so that they are only accessible to maybe say specific members of the judiciary or just judicial officers as such. So the system has that capability. But right now we did a proposal for developing rules on anonymization of cases. They can decide to anonymize at source. So that, I don't know if any of you remember those movies where there was John Doe. As ULI, the sanctity of a decision is not changed. Even if you make a mistake, we shall not tamper with that specific decisions because we are not appellate courts. So as a decision comes is how we upload the specific decision. Thank you very much.
But restrict access. If you write a decision like the one we have been discussing yesterday and the one we are going to look at just now, can you will be able to say, but this one shall not be accessed by
the public,
the world?
Yes, my lord, we can do that.
Because that's where my problem is. There should be a corner so that it becomes the corner of shame. You can't have that corner. Yes, sir. Give it to Judge Amos.
That was exactly my concern, that even tabloids, before they send those shaming stories, they have an editorial board. So I entirely agree that we must restrict, we must ensure quality judgments to spread to the whole world. My lord, the leadership of the editorial board, I don't want to doubt it, but his worship alone may not really sieve judgments of Supreme Court, for example. So I would want to say or suggest that the leadership must be available to go through these judgments. Now, are they going to be dedicated only to this because it's a daily work, or they are also in the courts? If they do both, how effective are they going to be? So there is a lot of discussion there.
Yes, the human resource, availability of time.
Mine is a question. You have Department of Law Reporting at LDC. How do you interact with them? And there could be a possible source of assistance. The other one is a comment about Tanzania. So you know Tanzania is very tricky. I'll tell you, I have been part of their sector, communication sector. So they reached a point where the English had fallen very far behind. Although now today, when you look at their documents, they are so perfect. They are using AI tools. Charge sheet, indictment, they read everything in Swahili, it translates to English with perfect punctuation. So for them, it is not what you see every day in the courts. It is also now backed by a very expensive system which translates, edits, and reproduces. Thank you.
And yesterday we learned that they have also now compulsory English lessons for lawyers. Well, the law is written in English, whether in Tanzania or here. For them.
Yes, so Parliament, when Parliament is legislating now, I think since 2018, all acts of Parliament are published in Swahili. So, but now, what they have done is they have realized they missed a lot of years going that direction. But the international community requires, and commerce requires, that you have proper English translations. So their investment has been in the translation and reproduction side.
That's emphasis on AI.
AI and other tools, yes, thank you.
I think we shall stop there on this and go to the next. Because tomorrow we want people to go to, I told you to check their farms. Yeah, so let us now go to our next thing. We have, I think we appreciate it, but let's give him a bonus because of his good act. We have 2 judgments here. We have 2 sets of files. One is a judgment. The other one is a file kept by a judicial officer and his group. I would think this should be our last breakup into groups. We want to look at those files. 2 groups will deal with the judgment. 2 groups will deal with that file, the other file, and tell us whether it is in order or not. It's not as clerical as some people think, because really having a proper file is a judge's and a magistrate's duty. You are the one who needs to read it and make a decision. I was telling friends of mine that one time I went to Ginger and I went to the registry. While in the registry, the resident judge came. He was passing by and someone says, Judge Wangutus is in there. So he came. He entered and says, hey Judge, what are you doing in the registry? I mean, what are you doing in here? He said, I've come to check on these files. And he asked me, which office is this? Is the resident judge there? He was the resident judge. Alan, you know Ginger Court very well. There's the corners. So I said, my lord, this is your civil registry. But he had been there 2 years. So it means his job was, I'm not an administrator. Enter court, get out of court and go home. Enter court, get out of court and go home. You must walk your stations. It's only then that you will know whether the registries and the registrars are doing their bit. So these are the files you are going to look at. They have questions in them. One of them requires us to identify irregularities in the entire record. Can you write a good judgment out of such a record? What will be the effect of the irregularities on any ruling or judgment made? They all have those same questions. Then the other set has, you are to identify the irregularities in the record, and whether you can write a good judgment out of that record. And then it asks you to find the remedy. What is the remedy? So that is what we are going to do. So group 1, we are giving 3 files to each group. This is Muko. So group 1 and group 4 will do the Muko file. Who is the representative for group 1? Representative for group 1. Or you don't or we do election by standing in lines. You are the representative there. And who is the representative of group 4? Group 4, do you have a representative? I know the leader is here, so you will come and find them with your leader. And then group 2 and group 3 will do this. I know there is a representative of group 1, group 2, or 1, that's 1. Group 2, who is the representative for group 2? You are in 2?
Started with 1 and 4.
I started with 1
and 4.
And 4.
Yes. Then there could be 2 and 3.
1. 3. I group 3. Group 3, what is group 3? So they are so simple, straightforward, but tricky. They are just, you've got to make an effort to face them. So it is now a 1:30 meeting. We can work up to lunchtime, and you can set the lunchtime. What do? We work up to 1:30 or 1? Okay, let's do it. It is easy. It is easy. Let us report at 2. Judicial officers who, yes sir. Group 1 are there. You are represented. Yeah, we have lunch.
It's not yet time.
It's not yet time. It is not past meeting. Yeah, that's important part of this place. Let's agree, when do we go for lunch? At 1:15. 1:15. Then you come back at 2:15. We go to work up to 1:15. Then we come back at 2:15. Tomorrow we are going to look at the workings of ECMIS and the ICT, the judicial. That should be by for us. Yeah. Okay then, can we go and begin now so that, because if you procrastinate, then you will get a problem. Let's go and begin now.
AI.
It doesn't have
Now that
it doesn't have to work for you. Then it tells you. So now they have begun with some people using AI for their judgments.
I should, instead of relying on the person assistant, who can generate a draft. Gives me a draft.
You will give a draft, then you polish it.
You polish it.
Because it's also dangerous. And very, our interpretation is different, and so on. That's what do I say?
Yes.
This, if these are ours, we retain these. Okay. So that when they are presenting you, we have something to look at.
We should know what they are talking about.
Yes. Yes. Yes.
Thank you, madam.
irregularities in the entire record. And there was an inquiry whether a good judgment could be written out of such a record. The third one was the remedy. The third question was about the remedy to such a problem. So the file was Uganda against Ekisa Patrick alias Muko. The record had papers mixed up together. We found several irregularities. There is a charge sheet that has A1 Sazi Christopher and A2 Akampuria Dennis. And yet the file is for Ekisa Patrick. So we found, in addition to that, to the charge sheet of Ekisa Patrick, that charge of Sazi Christopher and another. And we'll go straight to the irregularities. The record appeared to have got burnt. I don't know if it got burnt or fluid poured on it. There are stains all over. And then it appeared the officer also probably took it home and a child wrote in it, because you see the pages have some writing marks that are not necessarily signatures, and go through the writing of the officer. So the record has missing information due to the damaged record. There are two charge sheets that are distinct in content, and it is therefore probable that the proceedings are for two different files. It is not very clear whether all the proceedings on this file are for Ekisa. The page numbers are not arranged in order. The pages are so badly numbered that you can't follow by looking at the file which one follows. The handwriting is not so legible. It is actually illegible, although part of our members thought that was a very good handwriting, but I think that is by way of defending their own. So we notice also the charge sheets were not dated after the judicial officer signed, and then the record is not bound. The papers are all, both charge sheets are not dated. The one of Ekisa and also the one of Sazi Christopher and another. The record is not bound. The record is improperly numbered. Some pages are actually repeated. Page numbers are repeated. It's hard to follow. And then the record as a whole does not speak for itself. It is not dated. As you read the pages, you can't know which day the court sat and what day they adjourned to. Everything is everywhere. Yeah, the record is partially destroyed. The exhibits are so poorly marked. It is not clear when they were received or who received them, or if they are actually exhibits on the file, because they're just marked PX, so we cannot tell whether in fact the judicial officer admitted them on the record. And the second question was if from this record you would come up with a proper judgment, and we concluded that it would be very, very difficult and impossible to come up with a judgment going by the record as is. And why? Because of the irregularities that we've already cited. And in question 3, what would the remedy be? As a group, we agreed that we would need to resummon the witnesses and rehear the case afresh under the auspices of section 144 of the MCA that allows a magistrate to start a hearing afresh when they have taken over file and they're of the opinion that it is only proper to have a fresh hearing rather than continuing on the evidence as is. even though this file was already at judgment stage. And then we also agreed that we would grant the accused person bail, since we note that he's already been on remand for 2 years. On the record, there is nothing to show that he had been given bail. So we'd grant him bail on his own recognizance and then proceed to hear the matter and come up with a decision. That is it from Group 1. Thank you.
Before we go into comments, let us hear the other group which did the same thing. Was that 4? That was Group 4? I think the computer group, their computer is there. So let's hear Group 4. Tell us what was required of you, because you have the questions. Tell us what was required of you, and give us a background of what the case is about, a short one. And then proceed with the Nani.
Thank you, my Lord. Good afternoon, my lords and your worship. This is Group 4. Our group leader is Honorable Justice Alan Nshime. My Lord, our group was given case file, Ekisa Uganda versus Ekisa Patrick, the number of 379 of 2023. And we are required to look at the case file and identify the irregularities from the court record. Number 2, we are required to look at the record and see if we can write a good judgment from the record of proceedings and the remedies we would suggest in the circumstances we are unable to write a judgment from the record. Next slide. My Lord, we looked at the record. First of all, we observed the file cover, which read Uganda against Ekisa Patrick as the accused person. However, when we looked on the record, we found out that there were 2 charge sheets. One was in respect to Ekisa Patrick, and the other was in respect of 2 accused persons, Sazi Christopher and Akampurila Dennis, who were charged with 3 counts of cyber stalking. So since the file cover was in respect to Ekisa Patrick, we took that to be some form of misfiling of pleadings or documents, because the file cover showed Ekisa Patrick, but we found a charge sheet in respect to Sazi Christopher and Akampurila Dennis within the same file. So we suspect it could have been a wrong filing. Then we also looked at the file cover and we identified that it did not indicate all the offenses with which the accused person was charged, the dates or the sequences of the appearances. You now record this date, then you adjourn to this date on the file cover for purposes of tracking the appearances. It was not in the file. Then the Sarabin number and the complainant number are not also indicated on the case file. And also didn't know which judicial officer was managing this case file, like how we do it in courts. They indicate His Worship Tendo is handling the file for purposes of tracking progress of the file. We could not tell that from our court file. We looked at the charge sheet for cyber stalking, which was in respect to Sazi and Akampurila, and also noticed that much as that file, we suspected the charge sheet to have been misfiled, it also didn't have the complainant number, or it was not also signed. Neither did it indicate was handling that file. So when we further looked at the record, my lords, we found that the record was burnt and the pages were all They were all burnt. Probably it was a fire. We don't know whether the judicial officer was a smoker and something happened with the court file. So the file pages were also not tied together. They were all just flying all over the file. There was no thread to tie the court file, purposes of being organized without court files. The file pages were also not organized in the same order. We could find a 2, then you go to a 4, then this side is a 3, so we could not properly track the sequence of how the file was moving. So the record on the court file had multiple page numbers on each page. You could see one page had a 2, then there was a 4 on, so a bit confused whether this was actually page 2 or page 4. There were multiple numbering on the pages from within the court file. So also note that the judicial officer did not sign at the end of each day's proceedings. You know, you're in court and then you're recording your proceedings and then you sign the date of that actual proceedings, like maybe 10th of this date, and then you sign. So the date was also missing on most of the proceedings for the days. So the judicial officer's handwriting was also very easy to read. So it was a challenge to read the record and write the judgment. So when you further look at the record, it appeared as though the child picked the record and just scribbled, did some doodling within the file. And then we also found that the same court file had a judgment in respect to Uganda versus Wamboka, which was a different case. Our record was in respect of Ekisa Patrick. So we wondered how the judgment in respect to Uganda versus Wamboka came on that file. Also, the date for plea taking was not clear. So, assuming there's a judgment, it would be hard for the judicial officer to calculate the remand period because it was not also known when the accused person appeared before court for plea taking. So when we read through the proceedings, my lords, we found also that the plea taking process was not properly managed. We saw that the accused person was produced before court, and we see the prosecution doing the introductions, and then the magistrate just directed that the proceeding, the charge sheet is read to the accused person in English. So we didn't know whether this person was actually comfortable with the language used by the court to read the charge sheet to him. Then also the accused person was never asked whether he has sureties to apply for bail. Remember we were told here that when a person takes plea, it is your duty as court to inform the accused person of his right to apply for bail. That was also captured on the court file. So when we further perused the record, we found that PW1 and PW4 were not actually sworn in before taking evidence. Or it was also not clear from the file that they actually explained two of these and they did not take it up. So it was just the magistrate coming or the judicial officer coming and starts recording evidence from the witnesses without taking oath. Then when we saw the ruling on admission of the exhibits, there was an objection raised by the accused person, but the ruling on admission of the exhibits did not, the judicial officer did not give reasons for admitting the said exhibits. And more so when he made the ruling admitting the exhibits, it was not signed. We were guided by His Lordship, Justice Alan Nshime, that it is good practice when you make a ruling in such circumstances that you sign there because someone has made an objection, there has been a reply to that objection, and you've made a ruling as the court. So we advise that it is good practice to always sign because that is your ruling as the court. So that signature was also missing from the ruling made by the judicial officer who admitted those exhibits. Then when we went to the cross-examination, the judicial officer does not record actually who is cross-examining a witness. We don't know whether it was the state, or it is the accused person, or it was actually the court, just like we saw yesterday in the magistrate from Mbarara. So I don't know that was the court doing cross-examination, or it was the accused person, or the advocate. So we also found that in instances where the court was asking questions, it was not clear where the court asks questions, it must be added as questions of the court. Yes, now from the record you would see the court, and then you see some kind of questions, some kind of answers down there. So I don't know what that meant. With the court, then you see responses down there. We don't know whether there were questions from the court. We really don't know what it was. Then we saw also pictures or drawings of a baby within the record. We don't know whether the magistrate or the judicial officer was just bored and began drawing a few babies on the court file. The record also did not indicate whether the parties were given an opportunity to file submissions on a case to answer. Now, when the prosecution closed the evidence, the magistrate straight away made the ruling on a no case to answer. So I don't know whether the parties were given chance to make submissions as required under the MCA. I'm getting the section. So the accused person was also not cross-examined, and there's no record of whether actually the chance was accorded and not taken. When the accused testified, the magistrate simply went to fix the matter for judgment. So I don't know whether the chance to cross-examine was accorded and was not taken up. We don't know there was also time or chance given to the parties to make submissions before the magistrate would fix the matter for judgment. Then the record itself did not show whether judgment was delivered. Actually, what appeared on our record was a judgment of Uganda against Wamboka. So having identified those irregularities, we were tasked to see if we can write a good judgment from such a record of proceedings and why. Now, we agreed as a group that it was not possible to make a good judgment from the record available to us, for the reason that part of the record is burnt, leading to inconsistencies in evidence. Even some of the witnesses could not be identified because that part had been destroyed, had been burnt. So we couldn't have clear evidence, and there was no chronology of the evidence to enable us write a good judgment. So when it came to the remedies, the first remedy we agreed upon was to recall the witnesses. And this remedy would be available where judgment has not been delivered. This remedy is available under Section 100 of the Magistrates Courts Act. However, I also agreed that if the judgment was written and delivered by the judicial officer, then you cannot have a recall of the witness. So we agreed that the remedy would be a retrial of the matter by an appellant court. Okay, this remedy would come in from the appellant court if there is. Yes, we agree that it is the appellant court that would order a retrial of the accused person. That is what we had, my lord, for Group 4. Thank you.
So can we thank this Group 4, which has also given us details of what that file has. And now, do we have any comments to make? Do we have comments to make? I'm going to ask the ladies here who have been working on those files to say something after that. Any comments? Members of those groups, do you have any comments? Yourselves? No? Okay. Now, Your worships, you people have been looking at these files. You must have noted certain things. You've also listened to what our sisters and brothers have given us here. Is there something we have left out that you can comment on?
Thank you so much. From the two presentations, I think that is exactly what, those are the issues that arose in those in that file. I think maybe what we didn't, because there's a group I think that only got the photocopies.
You introduce yourselves first.
My apologies. My name is Marlene Obizu, a magistrate grade 1 at Judicial Training Institute. Yes. What wasn't clear for a certain group is the fact that because they got photocopies only, but the original file is a burnt file, because when I was moving around, they were like, is this water or what is it? And also, if you looked at there were instructions, if you looked at the instructions, it was stated that the judicial officer had taken this file home, I think for purposes of writing a judgment or something. So all the burning, and if you had the original file, you find there were scribbles by a child, I think, with the highlighters or marker pen. So this file was taken home, and this is when some of these things happened. And the irregularities that we've all noted are exactly what was there. And then, and yes, we said it's not possible to write a good judgment out of such a record. And when you look at, that's of course based on the irregularities and all these other things that have happened. So the remedy, we had the same remedies, but we're saying that to avoid all this happening, let's always employ the best practices of case management and record keeping. And what are these best practices? Her Worship Esther will outline them for us later. So yes, those are my comments.
We are going to get tips of good management after the two of you.
Yes.
After the reports here.
Yes, my lord. Thank you.
Is your neighbor saying something?
She says no comment.
No comment. Well, what you've noticed is somebody goes home with the file of Azira Asire. I must write this one tonight. It must be delivered tomorrow. So you take it home. But you are at home, you have no control. We have this bed where the wife says, sit that way. He tosses him this way. In a court here, they look very powerful, but at home. At home, hey. I used to have a boss of mine when I was a grade 1, but Madam would slap him. Hey, Madam would slap him. So the staff at the office would say, but at home he's the one who is being hammered. Here he shouts at us. We've known a home where they quarrel and tear documents. A friend of mine lost his brand new TV. Madam was annoyed, so she broke it. It pains him. The man can always go to watch football outside. For you, you have a little bit of a problem. So when you take these files home, which once in a while must happen, you have a study. When you are building your houses, put a study there. If you have no study, then you must have a place in your bedroom where you lock. Otherwise, the children would begin writing. There is a lot of doodling in the file all over.
Those papers can even be used for
Yes. Yes, when we were registrars, we found our court records being used to wrap groundnuts, vegetables. By road, you remember, down in we know. Court files. And they were being carried from our store to be sold down there by court staff. They were the ones taking them there. So when you take these files home, please be careful. Lock it up when you finish and so on. Can we have group 2? Group 2. Does it exist? Yes. Group 2, you come and speak some English. Tell us what it's all about. Give us the brief facts of your case, and then proceed. Thank you very much.
Thank you. My Lord, Your Worships, this is Group 2, headed by His Lordship, Justice Karoli. We were given a record of proceedings where we were supposed to identify irregularities in the entire record. We were asked to point out whether we could write a good judgment out of the record and what would be the effect of the irregularities on any ruling or judgment made. The first thing we pointed out was that the record had no charge sheet. That was the first irregularity. There was no charge sheet. And perhaps that's why the record does not begin with a date, but the magistrate himself noting that the accused is charged by cyber stalking contrary to Section 26 of the Computer Misuse Act. So the first issue was there was no charge sheet on the record. It appears as though the magistrate turned himself into the charging officer or the charge sheet. So in that way, we were not able to find out when the proceedings actually commenced, because there's no beginning date in that file. Another irregularity was the judicial officer did not indicate the representation of who was in court the day the accused was arraigned for plea. We are not aware whether there was a clerk, prosecution. All we know that the accused was brought before the magistrate. Thirdly, we noticed that there was no plea taken. From the record, when you read it, it says accused presented before court, charge sheet read and explained, and the accused admitted understanding. From that phrase, the judicial officer went ahead and entered a plea of not guilty. So we found the judicial officer did not follow the steps as laid down in Adan versus Republic on how a plea should be taken. So on that step alone, since we noticed there was no clerk, the judicial officer did not indicate which language he was using to communicate to this accused. So there is doubt whether the accused person understood what was going on, because it's not clear if the two were understanding the language of court. So we realized that was also an irregularity. After the judicial officer entering a plea of guilty, he remanded the accused person. We noticed that at this stage it is important. No, plea of not guilty. Much obliged, my lord. We noticed that at this stage it was crucial for the judicial officer to inform the accused person their right to apply for bail, which was not done. We also noticed that the record, as the magistrate was closing off by the daily sittings, they were not signed, which was not proper, because anything can be smuggled onto the record. It's good practice to sign off whenever you're ending the day's record. We also noticed that the adjournment given was a little bit long. The guidance is we should normally, if someone is on remand, we should do 2 weeks. Here the adjournment was beyond that. My lord, we were trying to look for the law, then someone mentioned the lunch. We switched off. Much obliged, my lord. My lord, we also noticed there was irregularity in how the evidence was recorded of the witness who appeared in court. The record only shows PW1 police officer takes oath. Particulars of this witness were not given. We don't know his name. We don't know his rank. We don't know, because just says police officer. We don't know whether he's the investigating officer, the SOCO, clinical police officer. We don't know his age. And most importantly, he took oath and we don't know his faith. Another irregularity we pointed out, the record shows cross-examination nil. We do not know whether the accused persons were actually given chance to cross-examine and they declined, or the judicial officer simply denied them a chance to cross-examine. So the record is not clear on that. Then the record also shows a bail application. In this bail application on record, it simply states accused seeks bail and has a surety. We have no particulars of the surety. They were not indicated anywhere. The judicial officer simply says surety presented and evaluated, cash bail of 2 million. Cash bail of 2 million. So we are not sure of the grounds for bail themselves. We also realize prosecution was not given a chance to reply to the bail application. So we found all this was irregular, and the ruling for that application does not show the basis for which the magistrate came to a conclusion that the surety presented is evaluated and cash bail of 2 million is given. There is no basis for this, for the decision he made to grant a cash bail in the first place, and it being 2 million. We also noted that at this moment where a judicial officer is giving a cash bail, it would be prudent to advise the applicant in that application of their right to recover the bail fund paid, which was not done on the record. There was also an application to review the bail terms by the accused person. Again, we noticed this application was heard and actually disposed of by the magistrate in absence of the prosecution. And no reasons were given for why the magistrate was convinced to vary the terms. So we find this was not a proper ruling, and the process leading to this ruling, we found it irregular. Then on the record, we find that one of the accused persons applied to court to allow them pursue reconciliation. The judicial officer went ahead and allowed that process without an input of the prosecution. With President, we have Mulam. Yes, he has no case to answer. We found, yes, the judicial officer made a finding, but did not take a decision. Because what happens then? If you find he has no case to answer, the MCA is clear. You must discharge the accused person and acquit him. That is the law. Here I just made a finding, but didn't take a decision. However, we also fault the ruling itself because it has no basis of how he came to this finding. We don't see which ingredients he was looking at. We don't see which evidence he looked at to come to those findings. So the reasons for the findings are absent in that ruling. We found that ruling not to be proper. Because there were two accused persons. Doesn't make enough. There is no ruling on respect to A1 on the prima facie case. However, when we looked at the cover of the file, it is noted that A1 was convicted, A2 acquitted. So the record itself does not show how the conviction came for A1. That there is a gap there. We do not know whether he pleaded guilty. We don't know whether there was judgment delivered and he was found guilty. The record is silent. Actually, it ends only on finding a prima facie case on A2, and we applaud the chief magistrate. He gave an order for the refund of bail funds. So we go to the part B of the question, whether can you write a good judgment out of such a record? Our answer was no. We even failed to attempt to get a draft. Major reason was we had no charge sheet. That was the major reason. But with all these irregularities, a meaningful judgment could not be gotten out of that record. The third part, what would be the effect of the irregularities on the ruling or judgment made thereof? Yes, here we are. The irregularities would make the ruling or judgment a bad one, prone to a revision or an appeal. We highlighted A1 was condemned and had, and we also realized that if you attempt to make the judgment, it will spoil the image of judiciary in the public. The rulings that were made here, we found all of them irregular and cannot stand if appealed against. That was our discussion as Group 2. No second hand clap.
Thank you very much. You want to give him a third one. So we, again, just like we did the other time, let us finish Group 3, and then we hold a general discussion and go back to the faculty here to make their comments. Group 3. Thank you.
My lords, your worships, members present, good afternoon. My name is Kakuru Edgar, Magistrate Grade 1 Rubare. Members, this is Group 3, under the leadership of His Lordship, Justice Kwizera Amos. And this is our presentation. We were given a criminal case of 2 accused persons charged with cyber stalking contrary to Section 26 of the Computer Misuse Act. A1 was convicted and A2 was acquitted. Our discussion is not going to be much. So we have 3 questions. The first one is to identify the irregularities in the entire record. The second one, can you write a good judgment out of such a record? And thirdly, what will be the effect of irregularities on any ruling or judgment made? So, starting from the irregularities, looking at the court record, first and foremost, there's no charge sheet on the file. So we wonder how the court was able to proceed in a criminal case where there's no charge sheet. Secondly, we see from the first date, that is 25th August 2023, we see from the record that the charge was read and explained and the accused admitted understanding. However, the court, as per the record, did not inquire into the language understood by the accused persons. So the accused persons had a right to be asked which language they understand, and the charge should have been read and explained to them in the language they understand. And clear. And the trial magistrate did not record the pleas by the accused persons, because from the record we cannot find it anywhere. And automatically it means the trial court did not follow the principles under the case of Adan versus Republic. Because when the charge is read and explained to the accused persons, each of them should give an answer. And that answer should be recorded in the language, in the exact words used by the accused persons. And we have also noted that the court entertained the plea in the absence of the state attorney. So we wonder who presented the accused persons, who was charging them. So another irregularity is that the trial magistrate did not explain to the accused persons their right to apply for bail. And this is a constitutional right. You explain to them, then they inform court whether they want to apply and whether they have sureties or not. From the court record, we've noted that throughout the whole trial, there was no court clerk. So we wonder how was the charge explained to the accused persons if there was no court clerk? And who did the interpretation? We also noted that the judicial officer never signed the court record on any of the days when the matter came up in court. So it is a requirement that when a case comes up in court, after handling it, the judicial officer should sign on the record and date it on that date. We have also noted that from the record, only A2 was granted bail and A1 was remanded. However, there's no remand warrant on the file. So we wonder how was A1 remanded. And even for A2 who was granted bail, there is no bail bond form on the court record. And we've also noted that A2 was actually granted cash bail. However, there are no receipts for the deposit of cash bail. So we've noted that this is a case that was not properly managed by the trial judicial officer. Also on the record, the state never informed court of the completion of the inquiries. The case suffered several adjournments, and on a date when the state came with a witness, they just informed court they have a witness. However, they did not inform court that the inquiries were complete. Also, we've noted that the court recorded the evidence of PW1, a police officer, who took oath. However, the particulars of the witness are not noted. The names, the address, the age, they were not noted on the court record. The court also noted that there was no cross-examination, but we wonder by who. In such a case where there are two accused persons, the court should have noted that cross-examination by A1 and A2, and then given them the chance, and clearly noted that they had no cross-examination. The record that A2 was granted cash bail, however, the particulars of the surety were never noted on the record. Court just stated that the surety is presented and evaluated and granted cash bail. Furthermore, we've noted that the terms for bail for the surety of A2 were never mentioned on the court record. A2 applied and he was granted bail. However, the court did not mention on which terms were A2 bonded. Sorry, the surety for A2. We have also noted that the state was never given the chance to report. And reduced the terms from 2 million shillings cash to 1 million in the absence of the prosecution. And we believe this was a fundamental error by the court. The court having granted bail, we believe that this court was already functus official. We believe that the court having granted bail to A2, it was functus official, and it had no powers to review its own decision. And even if it was to reconsider the bail terms, at least the prosecution should have been represented. Another error that we noted is that there's no update on the outcome of the reconciliation with respect of A1, because from the record, A1 prayed court for an opportunity to talk to the complainant. So the prosecution simply closed the case against A2, and then the court simply wrote that the evidence against A2 does not establish a prima facie case and he has no case to answer. So in our view, the rules for writing judgments and rulings did apply to the ruling on a prima facie case. The trial magistrate should have summarized the case for both parties, that is the prosecution. Sorry, the trial magistrate should have summarized the case for the prosecution. He should have stated the burden of proof. And then he should have also stated the charge against the accused persons, together with the ingredients, and then the position of the law, as well as a decision as to why there is no prima facie case against A2. However, even the ruling should have been against both accused persons, not simply against A2. So we believe that these are very fundamental errors that went to the root of the case. More so, according to the record, the court record within the file, A1 was not convicted and A2 was not acquitted. However, when you look at the file cover, the trial magistrate simply noted that A1 is convicted and A2 is acquitted. So which means what is on the file cover does not reflect what is in the court proceedings.
Was the first accused ever put on his defense?
My lord, he was never put on his defense. It is not on the record. Now, moving on to the second question, can you write a good judgment out of such a record? And our answer is no, because of the fundamental errors that we've already noted above, and also the record is too scanty. So the third question is, what will be the effect of the irregularities on any ruling or judgment, if written? And in our view as Group 3, we were unable to write a good judgment with the required attributes using this record. And ruling in the morning, and I need not delve into that. So in our opinion, as Group 3, we decided that this is a case file that should be stated and referred to the High Court for revision. Because even if you write a judgment out of this record, you would be wasting time. It would be challenged. That's all.
Author of that file is still in the judiciary?
Yes, my lord. Yes, the author of that record is still in the judiciary.
Working?
Yes.
So that is the position we have. The person who did this is still with this life. No, I'm telling you. Is still with us, working and earning above 5 million bob every month. So, do we have comments? Anything we want to add to this? You have the good, take it to my brother there.
Thank you, my lord. It's actually a question. It's in relation to what he has just presented, and we had a debate about it. One of the issues he raised was that the trial magistrate took plea without the presence of a state attorney.
Yes.
And for me, my question to you, and I hope we can get a resolution, is that, okay, there are two aspects. There's the legal aspect and there's the procedural aspect. Is it procedurally improper when an accused person is produced before me to take plea without a state attorney being present? Because in many instances, they're never present during plea. Yes.
Well, who is presenting him?
Yeah. Usually, my lord, there are police officers or the orderly.
Actually, my history is that where I come from there, for many years, the police would arrest a person, write a charge sheet, and take him to the magistrate, and he would read out the charge to him. Only that here we don't have a charge sheet. In this file, there was no charge sheet.
My question was that if there was a charge sheet duly signed by a police officer,
yes,
and a person is produced in court,
yes,
is it procedurally improper for me to read the charge to them and take plea? The other issues of maybe brief facts or bail can be handled separately, but what about the issue of plea? Can I take plea?
Let us ask the former chief prosecutor.
Yeah, I think let's look at the situation. If you are in a situation of even where there is a prosecutor, why would you ever wish to proceed without the prosecutor? Yeah, you ask the state attorney to come in and you proceed. If on the other hand you are in Buhweju and there is no state attorney, then the police who arrest can, if the state attorney, if you can make arrangements for a police officer to be appointed a prosecutor by the DPP, and that person can prosecute. If there is a private prosecution, then you don't need a state attorney. But where you have a state attorney or a state prosecutor or a police officer, please prosecute with the because who is prosecuting before you?
I don't know, my lord, because now I would want to know.
But you know the Magistrates Courts Act provides for that situation.
Yes. Yes. Yes, my lord. Sorry for interrupting. I was just saying, in the event that they produce this person, let's say the orderly, in front of you for plea taking, and there is no state attorney and a state attorney cannot come to court, should I inform them to take the person back to police until a state attorney is present for purposes of plea?
Actually, in my view, what I will do is I would read out that charge to this man and hear what he says and remind him if I'm still waiting for the prosecutor to come one day. And we have, in history, when you follow the olden days, there were no prosecutors, there were no state attorneys. The person would be carried with the eyes of the grade 2 magistrate, he would take a plea and proceed to hear witnesses. So, which was very tricky for them because now he has to balance the two.
Yeah, when I became a DPP in 1995, we were, including myself, 21 lawyers, prosecutors. And the prosecution would only be conducted by DPP's office where there is a criminal session in the High Court. Over 90% of the prosecutions were being done by police. So it's only that we improved this situation. But if your situation work according to the situation you live in, but avoid prosecuting cases before yourself.
Half my time as a grade 1 magistrate, it was the police prosecuting before me. And we convicted many with the police. Yes, any other, yes, my lord, you seem to have wanted to say something. It has been said. Okay, that was the issue. But you remember those police used to prosecute in those days. When you were still a very young, vibrant young man, I remember you very well. Yes, any other comments, my lords? Are we okay? Yes, brother. Oh, first give it to him here. Just a minute, let me come that way. Justice Kafoze.
Thank you, my lord. I don't know whether my observation is premature, because my concern seems to be what is the remedy. We came up with different ideas, I think, in different farms.
The remedy for this one?
My own team, we finally zeroed in on a remedy, but we would love to have approval from the faculty.
The faculty is here. We are going to ask it.
My lord, in our case, in view of the record as we found it, we thought that this hearing afresh, and we were relying on the provisions of section 147 of the MCA. Was it 144? Yes, thank you. 144 of the MCA, my lord. Yeah, but we would like to be guided.
But hold, somebody has got to say, retry. So for you, For you, if the record was brought before you as a high court, you would direct a retrial. That's what you would do.
My lord, how does it reach the High Court?
The file
that one was also challenged to
and
us.
we expect to be having nice and understanding chief magistrates, and that's their duty, because they are supposed to read through some of these files and refer the file to the High Court for revision. We expect them to be doing that. I don't know whether they are doing that. Even we expect them to be referring files to the High Court for confirmation of sentence. Are they sending? Instead, when they write their sentences, because 2 years, after 2 years and above you must send, they give 20 months, 21 months, so that it does not go. Yet when it goes, it helps you, because you get to know where you have a problem. Let's begin with him and then come to you.
That the chief magistrates have supervisory powers, for which they should call for files, for which they could send for revision, for corrections and all that. But resident judges, these files are near you. When such irregularities occur, you call for them also. You have that power. High Court has supervisory powers over all judicial officers in your jurisdiction. You don't need to wait for the chief magistrate's orders. References. If you receive a complaint, it could be from anybody, or if you exercise your supervisory powers and see the irregularities, don't wait for anybody else.
Yeah, you will call the file, look at it, and at times it is good to call the parties to say something about that file before you revise it. Yes, you do that. So does that answer you, the solution? Right. Thank you. We had my brother behind there.
My Lord, Seruo Benjamin again, Chief Magistrate Chiruhura. When I was presenting, you particularly asked for the section on adjournment. Our group has found it. Section 122.2 of the MCA. The person on remand, not more than 15 days. Anyone on bail, 30 days. Cleared days. Thank you.
Is that happening? Is that how we are remanding? I've been watching, I've been reading. When we were in Guru, we put that same question. Because you people are remanding 30 days, you are remanding 24 days. Actually, you are remanding to your convenience, not the law. You are remanding to your convenience. 28 days remand. It is very common, especially in the Kampala courts. Can we have, meanwhile, this one?
With regard to remand for more than the reasonable period or the period allowed, you find these judicial officers, he has, when you look at his diary, every day he has almost 30 cases. 30 cases listed for hearing. So when he's remanding, you find the diary page is done, then he goes up. Even in margins, he's putting cases. During our inspections, we found those, and we would ask, they said, humanly, they cannot have 50 cases a day. So they end up pushing where there is space. So I don't know how this can be managed, my Lord. Am I right?
I'm happy. That won't justify the breach of the law. The law is very clear. So what you do is simple. Do you know how many files we were mentioning as lower cadres for high court in the places where there is no high court. 170 files, 60 files. You mention them. You mention why they tell you to keep this man for that period and he comes and talks back again to you is for you to remain informed of his position and for you to be able to ask state, what is the position? Yes, you mentioned. We were alternating. You reach a stage where you say, I will mention my files on Monday, or magistrate so and so will do mentions this week. Mention. So that you can't run away from the law. It is your problem as your case manager to decide how will I do or what will I do to remain within the law. The word, the law is impossible, is no excuse. Because this man has rights. He is presumed to be innocent until somebody proves him guilty. For you, you are putting him there for 1 month. And the law is saying don't. And in breach of law, I think the Judicial Service Commission, they are reading these things, they would frown at them, but maybe they also don't know. Maybe they also don't know. Next time I meet the chair, there I will tell him, this section is do something about it. You rather change the law than breach it. But I don't think I recommend the change of the law, because then the rights of these persons who have been locked up will be generally terrible. Madam, you had something to say.
My Lord, I think it was handled by His Lordship, the DCJ Emeritus. It was about the case we were discussing with His Lordship Kafuzi. Probably I would add that our fear was the accused person had stayed on remand for 2 months, 2 years, and we were looking at that procedure. We were assuming that this is probably a grade 1 court, which is a bit far from the high court.
So you may not sack him, but you can help him or reduce the impact on the people of what he's doing to the people. Faculty, do you have comments on what transpired here? Yes, please.
My Lord, in respect to the revision of the bail terms, Section 73 of the MCA provides that it's the Chief Magistrate who can revise the bail terms of the G1 or the High Court. So in that case, the magistrate did it without jurisdiction, didn't have jurisdiction to do so. And also when you look at the particulars of the witnesses, the witness who testified as a police officer, his age was not included, and even whether he was a Christian or a Muslim, it was not indicated. And even the way the evidence was recorded, it was very scanty. And my Lord, sometimes even on the record, you find that magistrates sit, witnesses are there, but nothing is recorded. There is no evidence. They don't record evidence on record. And in such a scenarios, you will find that other judicial officers may not be able in position to write judgments. And even if it's also even costly for the complainants to recall those witnesses to come back to court to testify before other judicial officers. And this also is a kind of delay. It delays judgment. Thank you. Do you have anything?
Yeah, I think mine is just to emphasize the fact that this is a real, yes, this is a city magistrate. Yeah, maybe something I didn't, something I didn't hear was when you look at the beginning, the record only says Uganda versus Sequoia and another. If you found such a record, you wouldn't know where this record is emanating from, which court. You would never know. Secondly, at the plea taking, the judicial officer states that both accused plead not guilty. So the issue of omnibus plea, which was I did not hear, and one requested to speak to the complainants for us to reconcile, but where this ended is not anywhere. Whether this case was concluded as regards to A1 is not indicated. A2, there was an attempt to give a ruling on a no case to answer, but after finding that there was no prima facie case established, whether A2 was acquitted or not is also not indicated. And then when you go to the cover of the file that we gave you, you will see that it indicated A1 was convicted, A2 was acquitted. But when you look through the record, you cannot be able to find those facts. I think that is it. Thank you.
They agree with you fully. Your findings are agreed with by the two members of the faculty. And we want to clap for all the groups that presented this afternoon. Very nicely researched work and quickly done, because you were given less than an hour within which to work. Now, the remaining thing in these very things are the best tips of management in certain matters, which Esther here, her worship, Esther is going to take us through. I'm going to give her a chance to introduce herself and tell us what she does, and then, but otherwise she's a member of the faculty of JTI.
Thank you, my Lord.
You have 10 minutes, so Tony should not take your minutes.
Good afternoon, my lords and your worships. My name is Nasambu Esther Rebecca. I'm a chief magistrate at the Judicial Training Institute. And I'm part of the group that organized these problems that we've looked at, the actual court files that that prepare those problems that we looked at, and indeed there's a problem, and we need better supervision of our colleagues and the courts. And since the numbers of the judicial officers have increased, I think the workload has reduced. So I think it would be prudent that everybody does their work pretty well and makes it in such a way that even if you're not in a station and somebody looked at your file, they wouldn't be asking the neighbors what words you've written, what they meant, or whether this record, this page follows the other. So, I have a slide, I have a presentation of about 10 slides, but I want to go to the end of best practices. Since we've gone through the beginning of what a good file should look like. And you have identified the problems in those files that we gave you. And indeed, as Her Worship Marlene said, I think we shall talk to the Chief Magistrate of that grade 1 to give them, first of all, a file that is properly minuted. This grade 1 should look at it and maybe learn how files are minuted, then give him a chance to see if he can do it again better than before. And if they're not learning, maybe something else will be done. But it is a learning situation, and many of our colleagues, and I'm afraid to say even some judges, they're having problems taking down proceedings. So this is an area that we have to train in. So now, yes, my lord. Now, some of the best practices in case management include this, that to avoid flying papers or misnumbering or typing of papers, always punch and string your documents immediately. And this, if much as possible, should be the judicial officer themselves. Most of them write and give the clerk the papers. But you don't remember the clerk is interpreting, maybe is receiving exhibits, so sometimes the papers get mixed up. And in so doing, you should number your work. Number numerically, like from 1 to the next. Don't put A, B, or C. Those are maybe for exhibits. So, and also write clearly and exhaustively everything that happens in court. If you've heard of what happens in Parliament, the Hansard, everything is verbatim. So even in court, our taking down of records should be in verbatim. If you have like court recording, yes, you are better off, but sometimes those machines let you down. Actually, in one court where I worked, there was court recording, the machine recorded, reached somewhere in the middle and stopped recording. So when the judge goes back to review the documents, and the transcriber had written, judge coughs, judge coughs, judge coughs. So the judge was so pissed off, I told the transcriber, stupid, who told you that was the only thing I was doing? Coughing, coughing, coughing. But the problem was the machine. Somewhere the machine stopped, but since that judge had been a grade 1, he'd recorded his main point, so he didn't lose his record. So even with court recording, you're not sure whether everything is being recorded. Have your record and write clearly. I remember when some of us joined, handwriting was one of the issues. If you had a bad handwriting, you'd have problems with your supervisor. These days, people scribble anything they want, but it's safer for you to write properly. So that even when you're reading through your proceedings, you don't get lost or you wonder, is this a letter A, E, or an O? When the letter doesn't seem to fit anywhere. And then also, as I said, you number your papers, record exhibits that have been produced, whether they're prosecution exhibits or defense exhibits. And if you have original exhibits, photocopy them, like say for land titles or agreements, and note that these are true copies of the original, and give back the originals to the owners. Please don't keep people's original titles or agreements in the court files. They have led to so many problems, because sometimes where you keep the files, people access them and take out documents. There is a court where I think a clerk who had even retired had taken out the original land title, and the land was worth billions. It had been sold on Entebbe Road, and we're going to look in the file, they find a photocopy. The original was out. And it was a police case, but all the time they solved the problem, the land has been sold to a third party when an original document is returned to the owner, so that they don't come back and ask for their document, which they took some time back, because some of them lose them. And if it's not urgent, please do not take the file out of the court premises. Like this burnt file, where the officer took it home. We don't know what happened, whether it got burnt by mistake, then the scribbling by a child. So I know sometimes we have to carry work home, but as His Lordship said, you keep it safe. Keep it safe somewhere in a study where the only access is you, or in a cupboard or wherever, where nobody else has access. Tony. Always register the files with CAS or ICMIS and update them on a daily basis after every hearing. This is very vital so that in case you've completed the matter, the results are reflected immediately. Yes, if like for example you have ICMIS and a file is entered or registered, you take plea, the person pleads guilty, you sentence them and the results are entered, that is it. So anybody who looks at ICMIS that day will find that so-and-so was charged, convicted, pleaded guilty, sentenced to this so many years, and the record is there. But if you don't update, then the work will pile up. Then you find that you have gaps in the system. And when at the end of month comes, your returns are not tallying. In your mind, you know you finished 20 files, the clerk is producing 10 files. And you ask where are the other 10, and there's no record anywhere. And always have a movement book for files. For example, in this case, where I say the G1 had reviewed the bail terms is given, so the file is called for by the chief. There should be a movement book showing that this file from a grade 1 moved to the chief magistrate on this day, even when it is returned. Because sometimes in that course of movement, the files get lost, or if the High Court calls for the files. Because for example, like in Kampala, you may have, when we are working in Mengo, you'd have like letters calling for files from Civil Division, Family Division, Commercial Division, Inspector of Courts, Chief Registrar. So if you didn't have movement books for those files, where the file has gone to maybe Family Division, the same file is needed by Land Division because it's touching an estate. So if you don't have movement, they will think you've lost a file, when actually it is one of those divisions. So you should have an officer who is trustworthy, who moves with those files or moves them and brings back a correct record. Previously, before like coming of ICMIS, so when execution was being done in High Court, when we'd finish a file, a civil file, and it's been taken to High Court for execution, before execution was now brought back to the courts, somewhere between Mengo and High Court, maybe on Rubaga Road or somewhere on Mirembe Road, a written statement of defense would germinate in the file. When it reaches the High Court, it is sent back to you that, Your Worship, it can't be a default judgment, there's a written statement of defense. According to you, there was no WSD, but somewhere between Mengo and High Court, the WSD grew up and went onto the file. So it would really disturb us. So all the judicial officers, we agreed that we are going to give the files to one trustworthy lady. She was old and had been in the system for long. She had even worked actually with the Supreme Court justices and had left her in that building. So she was the only person who would trust with our files that when you give them to Rose and she takes them to the High Court, they're not going to grow miscellaneous applications along the way. The way you gave it to her is where it will reach. But the other young clerks were really disturbing us. So those are some of the problems you face as a judicial officer. And some of your supervisors will look at you like, are you really serious? How do you enter default judgment when there's a WSD? I say, but Your Worship, oh my Lord, this document was not in, but because of the people moving the files who are not trustworthy. Always record all the parties present or absent in court. For example, in civil cases, when a lawyer brings their bill of costs, they will tell you, I was in court on the 15th of June, I was in court on the 17th of July, when actually in one of those days they were absent. But because you didn't record whether counsel was present or absent, you may give him the taxes for that day when actually they were absent. So make sure you write both names. If counsel appearing before you is Kafuzi Kwimara, please write the name as that. Don't just write Kafuzi, because there may be more than one Kafuzi, or Kiza. So we ask which counsel Kiza is this. Or don't write, kindly record both names. And clearly, it doesn't take long or hard time to write the names, even the names of the accused persons. And if the counsel is absent and they've given you a reason, please record the reason why council is absent. I know sometimes council can give flimsy reasons for being absent so that you don't give anti-WSD if you give them last adjournment. Tired of adjourning. Yours is not a court of record, so like you take offense. No, let us be patient, because actually High Court takes precedent over magistrates' courts. So you listen and give maybe where an accused person appeared in court, but the counsel was absent. In a criminal case, and the accused was on bail. There was a witness. The accused said, I can't proceed because my lawyer is in High Court. What the magistrate instead did is to cancel the accused's bail. That was very irregular, and it was a grade 1 advising. So I was sent to that court to make sure the accused is granted. But Chief Registrar called me to go back to that court the next day, where it is that happened in court don't augur well, and they look very bad for practice. As I said, try as much as possible to write legibly. Your handwriting shouldn't be like a chicken scratching something. Write clearly and write correct English and grammar. The language of court is English. Kindly let us not write in our vernacular, like direct translation from the vernacular to English. The proceedings will not be good proceedings or clean proceedings. And always have a backup system for your files. In case a file is lost or something, a document is missing, have somewhere where you have backup for your documents. That was the summary of what we've done. Thank you very much.
On the issue of the flying papers, the papers flying out of the file, that's entirely...
Where is Esther? You come.
That's entirely... If it means going to court with a punch, or the punching machine, what, stapling machine, or stapler, do it yourself kindly. For some of us who are still using hard copy, these other files, because the Kampala people in High Court, even up country, what I'm talking about may not be applying. But in the magistrates' courts, you can't run away from filing. You can't run away from hard copies. Kindly do the work yourself. You may get a clerk who will get a piece of paper and do it in the corner. In the corner here. And in the course of the filing, it will jump out. For me, I even used to cut my own strings. I would buy a roll and have a pair of scissors or a razor blade and cut a string to tie up those papers. Because if you leave it to the clerk, he or she will cut a very tiny one, and the papers will be falling out. And once, the moment you've recorded your evidence and one page cannot be traced, it becomes difficult to write a judgment or to know what someone said on that one page. So I thought I should alert you. It can happen to you. It can happen to do that work yourself.
Thank you very much, my Lord. I visit chambers of judges and magistrates, even now when I'm retired, because they are all my friends. But I also go there to do work. I go there to do work because I audit for the judiciary as the chair. Now, some judicial officers have turned their offices or chambers into registries. You find a heap of files like this, a heap of, hey, my Lord, all these are pending judgments? No. They said their registries are not safe. That the registries are not safe, files disappear, files do that. But what happens now? We are this way so many days, a whole week. And files are in chambers. What happens to those people who want to file documents now? To avoid what the judge has just said, that one document missing can create a problem. What is happening? For those who have, and you lock your chambers. We went to the West 4 weeks ago. They said, Danny, beyond here. And the chamber was locked. Of course, it was a Monday, and Mondays are very difficult days for judiciary up country. Out of, now Mbarara will be open, but you go up country on Monday. I was served with the summons to file a defense. I've been given 15 days within which to file. I have come to your station to file on the 15th day because I'm still okay. I've come to file. The file is not there. The judge, the magistrate, is up country. He went home, he went to burial, training, and so on. What do? I have come to file. I am in time. Where do I file? Oh, the clerk can receive it and later on put it on the file. But there will be no record on that file to show that a filing has been done. The record will be entered next week. And whoever is entering it will be lying to say it came last week. Because coming means filing. So what do you plan to do about that? Those who have done their, I know you have a big problem. The registrar's files disappear and so on. Yes, but you curb that. You don't turn yourself into a registrar. You curb that. The registrar, the registrar clerk who is playing around with the files, you deal with the fellow. Because the file can't deal with him. You deal with him. But now, the files are, you go, in Kampala especially, you find a heap in the corner, The registrar, there are no files. The judge, the files are with the judge himself. The magistrate herself. So you come back tomorrow when the judge has come. So you go back with your pleadings. Come back, and some of them are time bad, have time spans. You haven't done this within this period. It is not just that it plays around, but it abates. The language used, it abates. Without a court order, it abates. So let us take these small things that her worship and his lordship are talking about. They are serious matters, but they create a clog in the judiciary because the next thing is an application for leave to file out of time. And so you have another application which shouldn't have been there, and so on, and so on, and so forth.
So, my Lord, we move to resolutions.
Yes, my Lord.
I agree with my Lord that small things matter. Some of the small things, even files, your working environment. I visited the magistrate's court. sat in the office. He had cobwebs in his office. They said, but what are these doing there? He says, we have not received money for cleaning. But you then I said, why you call your office pretendant? He called your office attendant. He called him. I asked him to bring a broom. And I cleaned the cobwebs.
Without
said,
money?
Do you need money? I visited the station. At the entrance of the judge was a tony chair. I said, why don't you really repair this chair? Said they have not, they wrote to the PS, they have no money. How much is your operational fund? Some big money. How much would this cost? Some little money. Why don't we work on our environment? That specific judge, later, after 1 year, we had walked around and it was dirty, it was ugly. The place now has flowers, is well cleaned. Yes. The money amounts have not changed. Just look around yourself in every respect. You are a manager. My Lord, we begin.
Thank you very much. We have decided to do the resolutions today. First of all, let's thank ourselves for finishing for almost finishing the training. I think that what we've been doing was the last bit. We would have done tomorrow ICT, but it is not going to take place for reasons beyond the control of this training body. The person who is supposed to come is not coming. So therefore, we decided that Esther takes us through what she thought were things that we discussed in here, and then we see whether what she has written is correct, or it is lacking, or should be struck out, or should be amended, or more should be added to what she has written. So you will read. You have a Mzindaro there? Use this one.
My lords, your worships, good evening. My name is Murungi Esther Bigawa. I'm a magistrate grade 1, Judicial Training Institute. These are the resolutions that we picked from the presentations. Number 1, adhere to the judicature plea bargain rules, statutory instrument, number 43 of 2016. My lord, should they react before or after?
No, we shall follow line by line. So what did you say?
Adhere to the judicature plea bargain rules, statutory instrument number 43 of 2016.
I think it is a matter that is agreed that we should adhere to these rules
Adopt and practice best practices in judgment writing.
Yes, we said so that we should maintain good judgment practice in judgment writing by even improving on the judgments we were given here.
Adopt leadership principles of leading by influence aimed at results and not leadership of position.
Yes, gentlemen, ladies, have you heard that? That what?
Adopt leadership principles of leading by influence aimed at results and not leadership or position.
Yes. Yes.
Always navigate Hewley as a resource for research, precedents, and legislation.
Yes, I think we had that one today. It was beautifully presented. And I learned very many things I didn't know about Yuli. I will never write a bad judgment now again. Yes, please.
Adopt a judicial officer mediator mindset.
Say that again.
Adopt a judicial officer mediator mindset.
Yes. I think we said that as a judge or magistrate or registrar, you must take advantage of the potential of a settlement of a matter. Instead of saying, I must hear 13 witnesses. If you see that the matter calls for, it can be solved through mediation, you must. It is helpful to pass it over for the same. Yes, my lord.
But, my lord, that aspect, thank you very much, my lord. That aspect is very dear to my heart. And we had already discussed this with the senior resident judge because I needed his help. Earlier, the registrar in charge of mediation, Her Worship Zulaika, indicated that where there is a consent on record and there was no reference to mediation, there's no mediation file, it is taken that that is a consent arrived at by the parties on their own. So as a judge, you may not get kudos for it. My lord, in my own experience, in the few months I've been on the bench, I think I've settled very many cases through mediation. And because I engage parties, I take off time, I read the file, and then when the time comes, the file is called, I engage the parties. Actually, I spend more time talking than I spend writing whatever comes out. So in the end, I'm not able to capture what transpired in that discussion because I was part of it. So, but I end up recording a consent. So how do I account for my achievement, my lord?
Now you advise me, how are you going to become visible? How are we going to be visible?
My lord, when I had also just come here and we were the first set of acting judges, there is I think it's called a monthly reporting tool. Now, that reporting tool is done by these IT people in Kampala. And it has got, I think it had application granted, application dismissed. Then they had something they call judgment on merit and judgment not on merit, which I've never understood. Yes, so at one time I engaged my ICT person here and I said, no, this is not proper. I did work and I think you're not capturing it well, because when you look at it in a strictest sense then, it looked as if you've done 2 judgments. So I told him you need to add another column. I think if we were to promote mediation, and they normally tell us to report on mediation, if I mediate a file, I am the manager in this station, I believe the judiciary trusts me. And I record it, the matter is concluded. The issue is that it's concluded. It's an application for amending pleadings. In my opinion, those columns that they make of different categories should have a part that says settled through mediation. Because it will start capturing. We can edit the content and how it needs to be, but it will start developing on that reporting tool that they're already using. And in that way, it will start making mediations visible. We have magistrates who settle matters also through mediation. I think I one time had people here who have been doing a good job in their areas, but it is not captured in the reporting tool for which the judicial officers are evaluated. And it has to be, it must be there somewhere, and the best way is to be in that reporting tool. So my suggestion is to find another column to do that, and that may be what will sort out what we are talking about here.
My lord, I think you're emphasizing the question you asked the other day. Yes. And I told you I had asked the same question. The registrar had told me they had a reporting tool that reflects mediation. I said on that day that we shall give space to the registrar to report. Now we have no space. We are going to Kampala, you'll get that reporting tool to reflect mediation. It must be there.
Yeah, but the information I have is actually that tool is not by ICT. That tool is by Magistrates Affairs. that
No,
body
we are going
government.
to really work on it.
My Lord, Her Worship Zuleika, I think, took an opportunity to explain something here,
Okay.
which would have been like her answer. And she said that we only take it as a mediation that you've done if you opened up a mediation file and you wrote to us to tell us, have by they settled this particular matter in Mbarara. Now that creates two problems. It forces us to create another registry for mediation of matters.
My
Yet
Lord.
some things are handled. Yeah.
To the main file. So you must always have a mediation. So you must always have a mediation file. But let me ask one question. When you do that in court, and you turn what would have been a proceeding into a mediation and you get results, does the return indicate that Justice so and so finished this case? Yes. It does. What is painful is that it should indicate that by mediation.
Yeah, but what is worrying him is that they are telling him he should consult Kampala and allow him to open a mediation file. I don't think Kampala should supervise you to that detail. You
No,
run
all cases going for mediation must have mediation files. A case you are handling and during scheduling conference, you are discussing the case and people agree, there does not totally fall under the mediation file. It's only that you are now using your brain as a mediator to sort out a case that is before you, which we've done hundreds of times. But if you want it to read mediation, then you have to have a number, a registration for mediation, a file for mediation. Then it will read. Otherwise, I don't know how people will know. Are you going to...
but you are the one to open it.
Yeah, they have to open mediation files for them to be realized as this one was done through mediation. The process of mediation is different. The opening statements, another opening statement, wooing people to believe in you, all that type of thing. So that procedure is different. But the procedure under scheduling, which is a must, because the law says you must schedule, may not tantamount to what we want to. I think you are simply encouraging a settlement there. I would think so. But if there is a mediation, I do mediation at Twed Tower. And I'm given a file, not the main file. They give us copies, small things on which we scribble notes. And the reason is because should mediation fail, that matter, you cannot carry that evidence back to court for use. But I agree with you. If you can sit down and see how it can be brought within the ambit of mediation so as to reflect there as mediation, but it's going to be a bit difficult because mediation, they look at the number of the file mediated and say, they make an entry. Here they will not have a file for mediation, so they will not make an entry. But it will show that you are very hardworking, that you even finish judgments without writing them. Yes, please.
I've picked it as a recommendation.
Yeah, that recommendation
settlements should be strictly tracked and reported in IKIMIS to
What is
ensure
that? Say that?
mediated settlements.
Mediated settlements should, returns of mediated settlements should be
strictly tracked and reported to ensure proper performance recognition.
That's what we have said. Yes. Agreed. They have CAS. Yes, please.
Okay, resolutions. Participants should identify and submit mediation cases to the registrar, ADR, within 2 weeks after the training.
Is that what you have agreed?
Is it 2 weeks okay?
Can it be done within 2 weeks?
The only challenge is that we are still in, I can speak from Mbarara. We had already said identifying some matters at the High Court. But since we had court vacation, then I don't know if 2 weeks will be enough for our other officers, especially at the magistrates level. Yeah.
How long should it be? Should be agreed by
I think 3 weeks. Chilura is far away. 3 weeks is enough.
3 weeks, then it is. Yes, please.
Adopt best practices in case management that include timely data entry and effective record management.
Timely data entry and record management. I think that's okay. Yes? Next.
Encourage peer-to-peer review.
Did you discuss that? Peer-to-peer review? You don't talk to each other. Where did you get it from? They didn't discuss. They didn't discuss that. So next.
No. In-house in-house judicial officer trainings on ADR and other interventions.
Yeah, but we did not say you have training, you assemble people like this. We are saying leaders in their capacities should become trainers of people who work under them, so that what we have studied here, for example, when you go back and you are doing some case management street, you pass over that knowledge to your clerks, to your, because you should be on the same page if you are going to move. So as a judicial officers, you are a permanent trainer of those who work with you and those who work under you. You are finding it hard to train? Yeah.
I wanted to propose, I don't know if they captured the resolution.
Yes.
Propose that we have another resolution that we need to promote alternative dispute resolution. Alternative dispute resolution. I know it's already been talked about, but you see, if you take that, then as a manager, wherever you are, you're trying to promote all these things. And by promoting them, it means that when you have a staff meeting, you also talk about it. You say you need to have customer care. We need to see where we can settle the matters. All that may be there.
Yeah, that ADR be promoted by judiciary staff. Add that.
On the peer-to-peer reviews, we meant that judicial officers should not work in isolation, but should continue to consult each other. That came out.
We have already been told that that is how they work. So that is good. Consultation is good. We used to consult each other when we were judges in the High Court. You ring your friend, there's this thing. How would you do it?
Okay, those are the resolutions we came up with, unless you have any others.
We thank you very much. Those are the resolutions so far captured. Is there something that you think should have been captured but wasn't, so that we add it there? Yes, please.
Thank you, Your Lordship. I do not have a new thing. I would only propose a modification to one of the resolutions.
Yes, which one?
Her Worship mentioned judicial officers something mediation attitude.
We have already amended it. His Lordship there amended it by saying that members of the judiciary should promote ADR.
That is different, Your Lordship. My proposal is that judicial officers should adopt mediator mindsets and put off their judicial hats.
And put off?
Their judicial hats.
No, you can't put off a judicial hat. You do that, you are in trouble. Because then you know how you just create backlog.
As a mediator,
they must
Your
go
Lordship,
together.
I seek to be understood.
No,
once
when
you
you say put off the judicial hat.
As a mediator, Your Lordship.
No, do that when you are mediating.
Yes.
But remain a judicial officer in all other cases.
Exactly, Your Lordship. But the resolution didn't seem to clearly say that. Thank you.
Okay. Thank you very much. You want a judicial officer who is mediator-minded, isn't it? Yes. So we've understood it to mean that. Not mediator. Not when mediating. When you're mediating, then during mediation, the hat goes off. That part, I agree with you. But when you are not mediating, the hat comes on, and it must be very tight. Yes, thank you very much, Your Worship. Any other thing that should have come up but didn't come up? Okay. My Lord, that is what was there.
I think let's clap for ourselves. It's been good work. We are not closing now. The workshop shall be closed by the Chief Justice tomorrow morning. He has accepted to come here first before he goes for the other activities in Mbarara. Let's kindly all be here at 9. Take breakfast early. We are buying our own time so that he comes early, we all finish early and do other things.
Because he's going to do other things.
No, he was supposed to start there, but he has been convinced to come here first. So let's not disappoint ourselves. Can we have the administrators to tell us what to do this evening and tomorrow? And also add whether there is a working team.
My Lord, the Deputy Chief Justice Emeritus, my Lords, our distinguished facilitators, my Lords, the judges in the Southwestern Circuit, Your Worships, registrars and magistrates, good evening. Let's give it up to our facilitators for near the close as we wait for tomorrow. My Lords and Your Worships, I believe that by now you have all received your facilitation. I'll break it down for you. For those that were residents, you have been paid 20% of your per diem plus fuel refund. 20% of your per diem plus fuel refund. Those that were non-residents, you were paid your full per diems for 5 days plus fuel refund. And residents from Mbarara have been paid Safari Day allowances for 5 days. Those are the applicable duty facilitation rates in accordance with our public service standing orders. Your drivers and bodyguards were also paid their per diems. This evening, we are going to have a barbecue, and I would really like to request that you all be present. The Honorable Chief Justice, the Deputy Chief Justice, the Chief Registrar will be here with us. We will start at 7:30 by the poolside. There's lots to eat, and both soft and hard stuff to drink. So please come and be part. The Honorable Deputy Chief Justice Emeritus has invited us for a walk. Last time we were not many. let's join him. Let's shed off the 4 days of sitting that we have had and join him in a good, healthy walk. Tomorrow, as you've been told, let's assemble here early, probably a few minutes to 9, so that by the time the Chief Justice comes in, we are ready for him. Thank you very much. I wish you a blessed evening. Okay, so I'm informed there are 2 pools, so we are going to the main pool, the pool which is next to Elgon Restaurant. That's where we shall be. Thank you. The workers, let us meet at the reception at 5:15. 5:15. Our chief direction officer is behind there and he knows. I'm informed there are those who had not yet received their facilitation. The paying table is at the corner there. Please pass there and receive your facilitation. The dress code is smart casual. It's casual, actually. Be as free as you can. There's no standard. What you feel free in is what you dress.